It's now time to call the meeting to order, and I'm calling the meeting to order with our agenda posting. We invited members of the public to view a broadcast of the Board of Directors meeting, which is live at www.youtube.com/State Bar of Texas. We also provided instructions on how to sign up to speak at today's meeting. Sign-ups were available until 5 p.m. Central Time yesterday. Members of the public will speak under Agenda Item 5. And those members of the public joining remotely will remain in the Zoom waiting room until it is their turn to speak. Please note that the meeting will be recorded and the recording will be made public. The State Bar's Executive Director, Trey Apfel, will now call the roll.
Director Addy. Director Benish. Here. Judge Brown. Here. Director Browning. Here. Director Bullard. Here. Director Cantu. Here. Director Cavazos. Director Charbonnet. Director Cherry. Director Chiscano. Director Cochran. Director Courageous. Director Culpepper. Director Gomez has an excused absence. Director Gross-Didier. Director Harris has an excused absence. Director Harrison has an excused absence. Director Hicks. Director Hill. Director Huddleston. Director Castle. Director Kegg. Director Kugler. Senior Justice Learman. Director Linehan. Director Locke. Director Martinez. Director Masre. Judge McClure. Director Mateer. Judge Miller has an excused absence. Director Morales. Director Tony Wynn has an excused absence. Director Nicholson. Director Perez. Director Pineda has an excused absence. Director Popov has an excused absence. Director Pratt. Director Quadros. Director Rod. Director Sloan. Director Spaniel has an excused absence. Director Stafford. Director Stelly. Director Tabata. Director Thiagi Rajan. Director Tisdale. Director Tobin. Director Vargas. Director Vasquez. Director Venzor. Director Voss. Director Weinstein has an excused absence. Director Wooten. Director Work. Director Rampelmeyer. Director Michael Wynn has an excused absence, and Justice Young has an excused absence. Mr. Chair, we have a quorum.
Thank you, Mr. Executive Director. We now call upon Cade Browning to deliver the invocation.
Good morning. It's further proof that West Texas rules the world today. We have my friend James Cummins, the game warden from Buffalo Gap, Texas, here today, protecting us all. So please say hello to him. And if y'all will please join me in prayer today. Dear Lord, we ask for your protection of those in the way of the hurricane this morning. And we give thanks for being here today. We give thanks to West Texas. We give thanks for the moisture and the beauty and the majesty of your creation. We thank you for the opportunity to be together today and for everyone gathered here, because you promised us that where there are 2 or 3 gathered, you are there in their midst, and we welcome you here this morning. We ask for your enlightenment, wisdom, and support as we begin this meeting, and this year with Steve, Paul, and Trey as our leaders. Help us to engage in meaningful discussions and allow us to grow closer this meeting as a group so that we may nurture the bonds of our friendship. Please fill us with your grace as we make decisions that affect those for whom we are entrusted to serve. We seek your blessings on the task before us this year, and please bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and fairness, and our decisions with impartiality. We ask for your help in our efforts to protect and preserve the rule of law and the lawyer's role in it. We ask that you guide us in being open to the ideas and beliefs of others, knowing that all opinions are welcome here, and to be respectful of our differences and not threatened by them. Please help us to understand that strength, real strength, can always find compromise, and that by working together, we can find common ground to enable us to move forward with a shared purpose. We thank you for being our source of guidance today, and please accept the fruits of our labor on this board today as a mean by which we give full praise and greater glory to you. In your name we pray. Amen.
Amen. Thank you, Director Browning. We now call Director Alex Stelly for the pledges, United States and Texas.
Pledge to the United States flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pledge to the Texas flag. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, Director Stelly. At this time, we'd like to welcome any members of the public who have signed up to speak. Any member of the public joining us in person who wishes to speak should sign a blue sign-in card and return it to the staff. If there is a specific topic of discussion or agenda item you would like to speak on, please list that on the card. If any members of the public have signed up to speak remotely, you will remain in the Zoom waiting room until it is your turn to speak, and I will address you to indicate that you may begin. Each speaker will be given 3 minutes to speak, and we will notify that person when their time is complete. At this time, we would recognize Steve Bresnan to speak through Zoom.
Thank you, Mr. Chairman. Can you hear me?
Barely.
Okay. Well, I'm making these comments on my own behalf and not on behalf of anyone else. I want to fill in a blank here that remarkably has gone unfilled, and that is the question of whether the Supreme Court has the authority to adopt these rules. The answer is no. The legislature has enacted a specific statute, Section 81.102B of the Government Code, which authorizes the court to recognize for the limited practice of law only 3 types of individuals: lawyers licensed out of state, law students, graduate students attending a law school. These rules, the legislature has adopted a comprehensive scheme of licensure for those who can practice law, discipline, and everything that goes with occupational licensing. And therefore, under Article 5, Section 31A of the Constitution, these paraprofessional rules are inconsistent with the laws of this state. The courts have routinely held that that phrase means that the legislature has paramount authority over those 3 grants of authority that are in Article 5, Section 31A. The Constitution's plain language, both in the Separation of Powers Clause in Section 2, Article 2, Section 1, and in Article 5, Section 31, that the legislature has preeminent power in this area. The rules, therefore, and the State Bar Board, all lawyers ought to ask themselves the very first question: does the court have the authority to adopt these rules? Remarkably, that question has not been addressed by the court's working group, Access to Justice. I've not found anything anywhere where this serious matter has been addressed. This is a matter for the legislature. The court should ask the legislature if it wants additional authority in this area. In the meantime, the State Bar of Texas Board should vote no on these rules. The Supreme Court of Texas should stand down on these rules. Just about 2 months till the legislature convenes, and they could go over to the legislature and ask them for the authority that's necessary to do this. I'll be happy to answer any questions.
Hearing none, thank you, Steve Bresnan.
Thank you.
Jacqueline Carpenter joining by Zoom.
Good morning. Thank you for allowing me to speak today. I'm here to speak on behalf of Judge Melissa Morris. My understanding is that Judge Morris has applied to take the board certification exam. I've had the opportunity to practice in front of her. I've been a public defender for the last 13 years, and I think she's been a judge for about 3. And in those 3 years, she's been an amazing judge. I've actually practiced before her, and so I do have some idea of how she rules. There was an incident where a prosecutor basically called me a liar in front of her, and she said, you know what? We're not going to be disrespectful in my court. Both sides are going to respect each other. And that just goes to how she runs her courtroom. But also, there was a hearing with regards to bond that we had. And in that hearing, she very much so listened to what was coming from the witness stand in terms of testimony, but she also referenced the law. So when she ruled, her ruling was a combination of law and facts as she had heard them from the witness stand. And she merged those into an actual finding of fact. So it wasn't her saying, oh, I'm just going to rule in this particular way because I feel like it. It was her actually applying a lot of facts. She is an excellent judge. She does that on a routine basis. We have a lot of judges, if we're honest, that already know before the hearing starts what they're going to do. That is not Judge Melissa Morris. On top of that, in criminal court, sometimes you have people bring their children to court. She doesn't ding them for that. Instead, she offers the children snacks. So she's relatable. She knows how to connect to people. She's very respectful in her courtroom, and yet has a very orderly court. She is the epitome of respect and judicial discretion. I would ask that you please allow her to take the exam and become board certified. Thank you.
Thank you, Jacqueline Carpenter. Next, joining by Zoom, we have Vafa Jasemi Zergoni.
Good morning, and thank you for allowing me to speak today. I am here also to speak on behalf of Judge Melissa Morris. I am an attorney. I'm an assistant chief public defender with Harris County Public Defender's Office. I've been in this position for about 3 years, over 3 years now. I've practiced in 2 other states previously. And I'm here to speak on behalf of Judge Morris. I have practiced in her court. I believe Judge Morris to be compassionate towards individuals in her court, respectful towards both the attorneys representing state and defense attorneys. She's willing to always take the law into consideration, always take all factors into consideration, make her decisions based on both compassion, respect for law, and taking the Constitution into account when she's presented with challenging situations. She makes sure that all those accused are thoroughly advised as to their rights and their rights in her courtroom. She doesn't disrespect anybody. I've had hearings in front of her where she was listening to both sides, taking the case law, and making her rulings based on facts, law, and compassion. And so for all those, I also ask that the board allows her to take the board certification, as it's my understanding that now the requirement is for judges to take and pass the board certification. Don't know if that was the rule before, but it seems to be a new thing for judges in certain counties. So I, as a member of the bar and as someone who has practiced in that court frequently, I asked the board to allow her to take that exam. Thank you.
Thank you, Jafa Jasemi Yergani. Colleen Guido is now joining by Zoom.
Good morning. Thank you to the State Bar for all of your work and specifically for the opportunity to speak with y'all this morning regarding Judge Melissa Morris's appeal of her denial to sit for the exam to be certified in criminal law. I'll speak only briefly about Judge Morris's qualifications and character, though I could truthfully speak to that for 3 hours and not just 3 minutes. I can say without hyperbole that Judge Morris is one of the brightest, most thoughtful, and most passionate attorneys that I know. But I know that y'all may be more interested in why she should qualify under the judicial exception to the qualifications to take the board certification exam. It is true that Judge Morris has only been a criminal district court judge for 2 years. But as I was fond of saying when I was a felony prosecutor at the Harris County District Attorney's Office, every year practicing criminal law in Harris County is more like dog years. 1 year down here feels more like 7. The sheer volume of cases is remarkable for all sides of the bar, for the prosecution, for the defense bar, and for us, the judiciary. It is so large that the legislature has kindly and importantly given us 7 more felony criminal courts over the last 2 years, courts which were desperately needed to handle the volume of cases that each of us works through. We have criminal docket every day, we have trials set every week, and we all have several contested hearings daily. Judge Morris has presided over 24 felony trials since she took the bench just 2 years ago. And that's to say nothing of the writs she's handled, the motions to suppress she's heard, and the sentencing hearings that she's conducted. I hope none of this is taken as me thinking that the judiciary down in Harris County are better than anyone else. I wish the volume was less. And I'm always amazed at my judicial brethren throughout the state who have dual jurisdiction dockets. I could not do that. Who deal with rural counties and everybody knowing each other. I couldn't deal with that either. But I can also confidently say that between Judge Morris's experience before taking the bench and her experience since taking the bench, she is qualified to sit for this exam and she's qualified now. Please don't make her wait. She is an exceptional attorney, and I know y'all want us Harris County judges to be as qualified and as smart as we can, and she just wants that. So please let her sit for the exam. She will make all of us proud.
Thank you, Colleen Guido. We now call upon Roy Petty. You'll be given 3 minutes to speak. Sure, yes, please.
I'm one of the former chairs of the immigration section, and I'd like to speak a little bit about the paraprofessional rule. The THC and the Supreme Court elicited information from the sections before it prepared the rules. And in our case, specific to immigration, they asked us protections that we would like. We recommended to the Texas Supreme Court certain protections of non-citizens in the court. Those protections are a good start. They're not everything that we asked for, but we are pleased that we were allowed to have input into the preparation of those paraprofessional rules and that some other sections were allowed to have input as well. That said, our section counsel would like to help train these paraprofessionals if this program goes through. The reason is that we think that if we have a paraprofessional program, it needs to be a program that's going to succeed. So we would like to help with that success. And we certainly encourage other sections to help train and do what they can to make the paraprofessional program a successful program. Because if it comes into being, I think it benefits everyone that it becomes a successful program. That said, in reading the correspondence to the bar, there is a lot of criticism about the professional program. And I think that some of those concerns are valid concerns, and I think a lot of people feel strongly against the program. And my opinion is that it's the responsibility of this board of directors to address all of those concerns and to try to build consensus. If the program is going to go through, again, for it to become a successful program, I think there needs to be consensus. And perhaps one way to build that consensus is by creating an advisory group that could perhaps set metrics, monitor the effectiveness of the program, and perhaps to make advice on how the program could be modified to become a better program. Thank you.
Thank you, Roy Petty. Justine Daly, you'll have 3 minutes to speak.
Good morning. Thank you for letting us speak today. I'm the current chair of the Immigration and Nationality Law section of the State Bar, and we are grateful for the Supreme Court for working with us and giving us a carve-out so that these paraprofessionals will not be allowed to inadvertently harm immigrants. If the State Bar votes to approve the paraprofessional rules, the immigration section is prepared and willing to help, as Roy just stated. I think that the rules deserve more discussion, more thought, and revisions that by reading the proposed rules, it's still, if they are allowed to help family law or help estate planning, I think it needs to be more specific in there that they're not allowed to represent non-US citizens. And so we're willing to help you guys work on those rules. So thank you.
Thank you, Justine Daly. Teresa Coles, you'll have 3 minutes to speak.
Thank you. Good morning. I'm Teresa Coles Davila, and I'm the immediate past chair for the Immigration and Nationality Law Section Council of the State Bar of Texas. And thank you very much for the opportunity to speak this morning. As my colleagues just mentioned, we do feel there needs to be more discussion about the rules. And reading the proposed rules, there's no mention in each rule about except for or see this or referring back to the carve-out for the Immigration and Nationality Law section. So that could potentially create some confusion for paraprofessionals who are dealing with certain areas of law where they may be authorized to practice, and they may be getting into a situation where they're dealing with a non-citizen and think that it's okay to continue forward because they're authorized to practice in the bigger under the bigger umbrella of, say, an estate planning issue or a family law issue, and may not recognize that they really should not be touching that case because there is a non-citizen involved or there is an immigration issue there. So again, as Justine mentioned, my suggestion would be that there be some revision to those rules to specifically address in each section, except for or refer back to the carve-out for the immigration law and non-citizens. Thank you very much.
Thank you, Teresa Coles. Are there any other members of the public that wish to speak? I believe we've now heard from every public member who has signed up to speak, and the public comments period is now closed. During the remainder of the meeting, if there is a board member or staff who wishes to speak, please approach the microphone and it'll let you speak at that time. Please identify yourself before speaking. Now I move to the report for the chair of the board. We will entertain a motion for approval of the consent agenda and a second. Director Morales has moved. Is there a second? Been properly moved. Yes. Noel Hicks, yes, has properly seconded. It's been properly moved and seconded. All in favor signify by aye. Aye. All opposed? I saw Director Mateo raise his hand, so I didn't know who was actually getting the second. Okay. Now I'm going to call on President Benesch for the presentation of resolutions.
Good morning. It is my pleasure this morning, my honor this morning, to present board resolutions to two very deserving individuals. The first one is Roger Key. Unfortunately, Roger had a scheduling conflict and was unable to join us this morning. I spoke with Roger last night, and he wanted me to express his sincere gratitude to the board and also to send his regards to you. Although he's not here today, I want to take a couple of minutes to tell you a little bit about Roger's great, maybe that's him calling now, a little bit about Roger's great work for the bar and for our profession. Roger is a 48-year member of the State Bar of Texas. He is a life fellow of the Texas Bar Foundation, and he is a member of the Texas Bar College. He graduated from the University of Texas at Austin with a bachelor, it's the only time I'll do that today, with a bachelor's degree in finance, and he received his JD from Texas Tech University School of Law. Roger is the son and grandson of lawyers. After earning his law degree, he entered private practice in Lubbock and is currently a partner at Key, Terrell, and Seeger, LLP. He is a longtime and tireless bar volunteer. Among his many volunteer roles, he has served as a director of the Texas Young Lawyers Association and is president of the Lubbock County Bar Association, president of the Texas Association of Bank Counsel, and president of the Texas Tech University School of Law Foundation Board. Roger has also served on the State Bar Board of Directors and served as chair of this board from 2014 to 2015, where he worked to ensure that meetings were run efficiently and that all directors had a chance to express their diverse viewpoints. Roger continued his service to the State Bar by co-chairing the State Bar's work group on Texas lawyer needs arising from the 2020 pandemic and from the 2021 winter storm. That work group identified areas where the bar could continue or expand to its efforts to help members who were facing continued challenges from those two catastrophic events. Today, the State Bar of Texas honors Roger Key with a resolution for his outstanding efforts on behalf of the people of Texas, his dedication to the Lubbock community, and his unwavering commitment to the legal profession as a whole. And although unfortunately Roger could not be here this morning, he still deserves a hearty ovation for that. I just noticed he was over my head. I didn't notice that. Our second honoree is with us this morning, I'm pleased to say, and that is Justice Judy C. Parker, and who is joined by her husband, Scott, this morning. Thank you. And we had a nice conversation last night. I enjoyed that. Justice Parker is a 38-year, she started at 2, a 38-year member of the State Bar of Texas and a life fellow of the Texas Bar Foundation. She graduated from Angelo State University with a bachelor's degree and received her JD from Texas Tech University School of Law. For the first 9 years of her legal career, Justice Parker undertook a private practice here in Lubbock. She later served as judge of the Lubbock County Court at Law No. 3 and presided over the Lubbock County Recovery Court, which is a drug court that involves child abuse and neglect cases. Justice Parker then served as the administrative judge for all of the Lubbock County Courts at Law. During this time, the State Bar's Legal Services to the Poor on Civil Matters Committee honored Justice Parker for her service with the Judge Merrill Hartman Pro Bono Judge Award in recognition of her exemplary work to increase access to justice. In 2017, Governor Greg Abbott appointed Justice Parker to the 7th District Court of Appeals, where she continues to serve to this day. Justice Parker has a long history of volunteer service to the legal profession, including as a past director of the Texas Young Lawyers Association, and went on to serve as chair of the TYLA board. And she is a past president of both the Lubbock Area Bar Association and the Lubbock County Young Lawyers Association. She is currently a director on the State Bar Judicial Section Board of Directors and is a founding member, judicial master, and past president of the Texas Tech University School of Law American Inn of Court. Today, the State Bar of Texas honors Justice Judy Parker with that resolution for her outstanding efforts on behalf of the people of Texas, her dedication to the greater Lubbock community, and her unwavering commitment to the legal profession as a whole. Justice Parker, if I can ask you to approach the resolution, and while you do so, may we honor you.
Thank you, Mr. President, and congratulations again to our resolution honorees, Roger Key and Justice Parker. I'd also like to recognize that former Supreme Court Justice Phil Johnson has joined us this morning. He's waving me off so that I don't recognize him, but I'm still going to recognize you. Thank you for joining us here this morning. Now, the materials I'm about to mention are in, guess what? They're in board effect. And communicating with our constituents is a vital part of our service as State Bar directors. We've heard that before, and it is important, and it needs to be stressed at every meeting. It's important that we let people know who we are and how the bar serves the Texas lawyers and the public, and that we hear them, that we hear their feedback on how we can better serve them and our profession. The primary way we are asked to communicate, or ask you to communicate, is to at least attend one State Bar CLE and to present in your district before the end of the bar year in May. And that can be a short presentation, an update about what's going on in your district, in your area, or even topical. Prepared just for you are 2 PowerPoint or Powers Point presentations that you can give to each local and specialty bar. And they were aptly prepared by the State Bar staff, and they are very informative, quite comprehensive. These presentations are titled, Maximize Your State Bar Membership and Improve Your Practice, which is accredited for 1 hour of MCLE credit, including an hour of ethics. And, not to be left out, 30 benefits in 30 minutes, which is accredited for a half an hour of MCLE credit and a half hour of ethics. We made it easy for you. The slides are built out, and they are the key points are noted in the notes. So all you have to do is reach out to your local bars and have them set up a time so that you can address them. In case you don't have the contact information for your local bars, we have them provided in a local bar roster in your materials, and guess what? Board effect. We also have brochures that you can share with your constituents and make presentations from those brochures. Please let Communications Director Lowell Brown know as soon as you schedule a presentation so he can make sure that you have the latest version of the PowerPoint and any other material that you might need, supplemental or otherwise. And make a record of your presentation to be recorded as part of the State Bar performance measures, which are reported to the Supreme Court and to the public. Thanks in advance for your participation. But remember, board effect is there to increase your efficiency and your effectiveness and to reduce what? Printing costs, saving trees, by giving all of us the information we need in a single place. I mean, I still print stuff, you know, but, and it's secure. It's online and it's for us. And it provides secure access to everything we need to fulfill our duties as directors. Along those lines, directors, this is a reminder to please make sure that you are RSVPing for your meetings and you're completing your surveys and reviewing your meeting materials at or before the meeting through the Board Effect portal. Solicitation of candidates for chair for the 2025-2026 board. Board policy states, a second-year director who desires to be nominated for the position of chair shall notify the chair in writing before the second quarterly board meeting of his or her intention to seek that position for the following organizational year. Those interested should include a written statement that they believe would be informative to the board in its selection as of the chair of the board. If you are a second-year director and you are interested in serving as chair of the board next year, please send the letter of intent, and you can email me, and your statement to me by Friday, December 6th, 2024. We had a loss among our bar director community. Lucy Forbes passed away some weeks ago, and we were all informed of that and very saddened by it. Lucy was a tireless servant to this bar and to the Texas bar community. She'll be sorely missed. I know many of you have attended services or at least expressed your condolences to her family and to her loved ones. And at this time, I'd like to at least have a moment of silence for Lucy Forbes. Thank you. Director Shannon Quadros will now approach the podium.
Thank you, Chair Stafford. Lucy Harutonian Forbes, born July 27, 1971, returned to the stars August 25, 2024. She is loved here on earth and will be most remembered through her daughter, Laura Forbes. Her obituary said, "When you find yourself missing Lucy, honor her memory by seeking joy in simple things, like hugging a child, speaking for those without a voice, and loving recklessly." Instead of dirges or requiems, we will offer up a poem in her honor. The poem is "Do Not Stand at My Grave and Weep" by Claire Harner. Do not stand at my grave and weep. I am not there, I do not sleep. I am 1,000 winds that blow. I am the diamond glints on the snow. I am the sunlight on ripened grain. I am the gentle autumn rain. When you awaken in the morning's hush, I am the swift uplifting rush of quiet birds in circle flight. I am the soft stars that shine at night. Do not stand at my grave and cry. I am not there. I did not die. Thank you, sir.
Thank you, Director Quadros. She'll be sorely missed. And now we call upon State Bar Executive Director Trey Apfel.
Thank you, Mr. Chair. Good morning. Congratulations to Justice Parker and to Roger Key. When I had the privilege of serving as president of the State Bar in 2014, 2015, Roger Key was our board chair, and he was an incredible leader, is an incredible leader, and a great contributor to the legal profession. So thank you, President Benish, for that wonderful honor. So I want to give you an update on State Bar happenings, leading off first with our local bar leaders conference that was held in Houston. It was very successful. That conference helps us fulfill our statutory obligation and requirement to, and I quote from the code encourage the formation and activities of local bar associations. So thanks to TYLA and our Texas Access to Justice Commission for partnering with us as co-hosts, and thank you to all of the board members who were able to attend and support us during that conference. You bring credibility to that effort. Thank you again. Also, had some great meetings that we attended with the National Association of Bar Executives, the National Conference of Bar Presidents, and the Southern Conference of Bar Presidents. We had meaningful discussions and sharing of ideas with other unified bar leaders. And I also had the opportunity to lead a panel discussion on Boudreaux compliance. And with the help and guidance of Chief Legal Counsel Chris Ritter and our Communications Director Lowell Brown, they prepared me for that opportunity, and I joined in with bar leaders from South Carolina, Louisiana, and Washington, D.C. In that presentation. Also, we just celebrated our 17th Leadership SBOT class. They had their first meeting last week in Austin. It's a great group that represents the diverse demographics of our very diverse state. Thank you to all of our staff members, including Jennifer Reams, Karen Chevins, Tracy Brown, and Kaylin Laney, for all of their hard work in making this program a success. They work on this program all year long, and there's 2 meetings that take place, one in the fall, one in the spring, and then the class graduates in June at the annual meeting where they provide details on their projects. This program has been going on for 17 years, and it is a great leadership program. Texas should be proud, and so should the State Bar. I know you are. I want to give you some updates on staff leadership positions, beginning first with Michelle Fontenot. I'm pleased to report that she, as you know, she's the director of our TLAP program, our Texas Lawyers Assistance Program. She's been appointed as a member of the ABA Commission on Lawyer Assistance Programs. The mission of the commission is to assure every judge, lawyer, and law student has access to support and assistance when confronting mental health and substance use issues. And this mission is carried out, obviously, by supporting our local lawyers' assistance programs as they provide hands-on services and support. I also want to recognize Lowry Kraft. He's our compliance supervisor for our MCLE department. And he is serving as co-chair of the Long Range Planning Committee of CLE Reg. CLE Reg is the Continuing Legal Education Regulators Association, and they provide an opportunity for, again, the discussion and exchange of information among administrators of mandatory MCLE programs across the country. So with Michelle Fontenot and Lowry Kraft, these are a couple of the latest examples of how Texas continues to be a national leader in bar association work. We're proud of their efforts, and I continue to encourage our staff in this regard. This November marks the 35th anniversary of the Texas Lawyers Creed. The Supreme Court and the Court of Criminal Appeals in 1989 promulgated the creed to help eliminate abusive tactics within the practice of law and to promote respect and confidence in the legal profession. As part of the anniversary celebration, the State Bar's Professionalism Committee, with assistance from our staff, has distributed brochures to attendees. They did so at the annual Judicial Education Conference earlier this month in San Antonio. If you or any lawyers you know are interested in getting your own free copies of the Creed brochure, you can email professionalism@texasbar.com. Next in your materials, we provided the newly published annual report of the State Bar. I want to thank our State Bar staff and our court and our board of directors for your support, because as you review that State Bar annual report, you will see the tremendous amount of of success that goes into our programs and our activities and our efforts on behalf of the legal profession. We also have provided the annual report from the Commission for Lawyer Discipline, and also we've provided at your seats the new volunteer and staff guide. So please take some time to read over this material and these reports and learn about the great work being done on behalf of Texas lawyers. Next, I want to recognize, given a Staff Excellence Award shout out to this quarter, David Espinoza. David began working at the bar in June of 2023 as the graphic designer for the Texas Bar Journal. In that short period, he has proven himself to be an invaluable member of the TBJ team and the communications division, demonstrating a strong work ethic, a positive demeanor, a can-do attitude, and an excellent knowledge of design. David is very mindful of deadlines and quick to design pages, upload files, and communicate with stakeholders. He takes the initiative and time to explain the reasoning behind a design idea or the reason why something works or doesn't work. This has proven beneficial to his team members and other departments at the bar when troubleshooting printing problems. David quickly developed new systems and processes that have streamlined our work. He easily adapted to the existing software used to design the TBJ, but we quickly realized that with his expertise in Adobe InDesign, David would be the perfect person to lead us to switch over to the industry standard software, something that we've been wanting to do for years. Switching software was a major project with a lot of moving parts and pieces and technical details that I won't get into here, but suffice it to say that David did the legwork and led the TBJ staff through the detailed InDesign training. As a result, we used InDesign to lay out the September 2024 issue, and we haven't turned back. David's commitment to his craft, his energy, and his devotion to the State Bar are to be commended. Please join me in thanking David for his hard work. And finally, I have the bittersweet task of saying a few words about Ray Cantu. It's bittersweet because Ray is retiring from the State Bar after nearly 30 years of service. We're happy for Ray for this chance to spend more time with his wife and daughters, more time traveling, more time just enjoying life. As he leaves us at the end of October, he can do so with the knowledge that his impact on the State Bar has been deep and lasting. Ray graduated from Texas A&M University with a BA in political science and earned a Master of Public Administration from Texas State University. Prior to joining our staff, he worked in the office of the governor from 1992 to 1995. Ray began his career at the State Bar in August of 1995. He's held many roles, including Director of Advertising Review, Attorney Compliance Division, and Special Projects Department. For many years, Ray has served as our Deputy Executive Director over the Compliance, Administration, and Information Technology divisions. He has worked closely with this board through its committees, including DCAP, Nominations and Elections, Facilities and Equipment, Appeals Grant Review, the Committee Review Task Force, and the Ad Hoc Committee to select at-large members. When I was hired as Executive Director in December of 2017, I quickly learned how integral Ray is to our operations. I also observed how well respected he is and has been among our staff, among our board, and among our leaders. And I also know how much he truly cares for the State Bar, our employees, and all Texas attorneys. Ray's been by my side every day since then, providing leadership and solid counsel, not only to me, but also to all of you. Ray has mentored countless staff over the years and always led by example with his work ethic. Speaking about Ray, one direct report said, "I've never hesitated to come to him when I needed advice or made a mistake. He always took the time and the patience to help me figure out a pathway out of a problem and never shied away from an issue." Another staff member said, "If Ray can help you, he will. His management style empowers his teams and instills confidence, creating an environment where everyone feels valued." Ray's deep institutional knowledge and experience have been invaluable, guiding us through challenges with insight and wisdom. Most importantly, he genuinely cares about his team, always taking the time to ask about their lives and offer support. And another employee put it this way, "Ray made everything seem effortless, someone I could bounce ideas off of, and his impact will be felt long after he has departed." Ray, as a token of our gratitude, we want to recognize you today with an award that reads 30 Years of Excellence, Ray Cantu, for your sound judgment, careful insight, and unyielding dedication. You'll join me up front. Mr. Chair, that completes my report.
Thank you, Executive Director Apfel. I got licensed in November of '94. I knew that there was a building at Colorado called the State Bar Headquarters. And from about 8 months after licensure, I knew Ray Cantu was at that building in Colorado called the State Bar Headquarters. So almost my entire period of licensure, Ray has been a fixture, along with others, but Ray has been the go-to person. And so again, I would like to applaud and thank Ray Cantu for his 30 years of service. Thank you so much. And now I call upon our State Bar President, Steve Benish, to provide his report. Steve, the floor is yours.
Thank you, Chair Stafford. Again, good morning. Again, good morning. There are three things I'm going to touch bases with you about. First is my general report on how the last quarter has gone since our last time together at the annual meeting in June. To talk a little bit about yesterday's solo small firm CLE that the State Bar put on here in Lubbock, in this room, as a matter of fact. And then finally, to turn the virtual gavel over to former State Bar President Sylvia Brunda Firth to talk a little bit, give us an update on the building planning. First to the general report. A couple of months ago, I was talking to our friend, Alex Stelly. Alex and I both graduated from high school in Beaumont, as did President-elect Vargas. So, matter of fact, Santos and Alex graduated from the same high school. So we kind of get each other. And Alex posed the very good question. You know, the traditional format of the general report of the president at these meetings is to kind of keep the spotlight on her or him and to talk about just about our travels and kind of have a scrapbook of travels and list out all these events that we've been to. We've always done it that way. I did it last year as president-elect. So it's just been the traditional format, but he questioned, is it possible to turn the spotlight on others during that time? And I thought that was a great idea. So I'm not going to show you a scrapbook of my travels, not directly at least, nor list for you the 39 events that I attended since the annual meeting, other than to say they were State Bar events, section events, at State Bar section events, local bar events, young lawyer events, affinity bar events, law-related organizations, several visits and speaking engagements at law schools, and one baseball game of the Amarillo Sod Poodles, which demands further explanation in a bit. But you may recall that Chair Stafford challenged all of us, and I joined in that, in being the voice and face of the profession where we live and work, and to serve that messenger liaison role, both ferrying information about the activities and goals and initiatives of the State Bar to our local constituents, and also ferrying that information from our local constituents back to this august body. And so I join in that, and I'm pleased to report to you that I'm going to show you pictures that I took with 32 of you while on these 39 trips, and looking around the room, and I've already apologized to a couple. There are several more who are not featured in this, who I did see and hung out with, and I failed to take a picture of you. You may have taken a picture with me, but I didn't take a picture with you, and so my apologies to Pierre, among others. And so let me go ahead and walk through some of our travels, some of the folks I saw, and I do this to commend you, to shine the spotlight on you for being out there, because though the bylaws may state that the executive director and president are the voice and face of the bar, you really are. We really are where we work and live. So first, it was a wonderful to be able to be with Judge Jerry Bullard at his ceremonial swearing in. Yes. At his ceremonial swearing in by Governor Abbott at Texas A&M. Okay, there you go. Texas A&M Law School. I know. Sorry, David. Last week. And so we are excited about that. It was a pleasure to be just this last weekend at the San Antonio Bar Foundation's gala, which was chaired by Foundation Chair and co-chaired by Patty Vargas. And you may know Patty Vargas's husband, who's sitting up here to the left. But the Bar Foundation Chair is Steve Ciscano, and he did a wonderful job, and we had an opportunity to take a picture together. I got a picture with a couple of our local section representatives, both Akenda Culpepper and Tony Wynn at the State Bar offices in Austin. I got a picture together with Stephen Vinzer and Chrissy Castle, with Noel Hicks at a Texas Minority Council program in Austin, with both immediate past Chair Kenan Wooten and Lowell Kegg at an event again, and Eva Guzman, I see in the picture, at an event at the State Bar headquarters. With Hisham Masri, we attended a meeting of the National Conference of Bar Presidents and Bar Leaders Conference together and snapped that shot just this last weekend with Senior Justice Deborah Lehrman and the very famous Sister Grace, for those of you who know her, on Deborah Lehrman's left. Allison Martinez and I got to speak together at Thurgood Marshall School of Law down in Houston, which was great fun. That's TYLA president-elect, of course. Rudy and I think went to virtually every event together. Rudy was at many of those, but this is, again, at a Texas Minority Council program in Austin. Judge Bill Miller and I were together as well with, that's TYLA board chair Courtney White, at an event in Austin. And there's Lawrence Morales with June Moynihan, who's the executive director of the San Antonio Bar, at a San Antonio Bar event. Rosalind Perez and I were together at the Advanced Family Law Conference. Saw a couple of folks there. And then up here in Lubbock on a previous trip, was with immediate past president Laura Pratt, along with, what is Garrett Count's current position? Is he president-elect? He's secretary of the TYLA. No, of course, you're president-elect. TYLA secretary. And then again in Austin in a Minority Council program, I saw both Shannon Quadros and David Courageous. And then at the Family Law Conference, ran into Chris Nicholson and took a picture together. And I took the way too close shot of me with Amy Rod, also at that conference. Then Paul Stafford and I had breakfast together with some of the local members of the Amarillo Bar on a trip that we took. And then, of course, my dear friend Cindy Tisdale, immediate past president of the State Bar, and I were at several events together. This one, I think, was in Fort Worth, at a Fort Worth annual luncheon. And this, on the left, that's Patty Vargas's husband that I was actually got a picture with. This was a luncheon in San Antonio, the annual meeting of the San Antonio Bar, where Patty Vargas was sworn in as the 24-25 president of the San Antonio Bar Association, succeeding Steve Chiscano in that role. And I don't know if you're on social media, if you had an opportunity to see Santos's post praising Patty, not only for her accomplishments, but who she is. It's the most moving social media post I've seen in a long time, so kudos, big guy. That was well done. I got to see Brandy Voss at the Advanced Appellate Law Seminar. I have no idea who that fellow with the untucked shirt is. Chad Brook, past board chair of this board. And finally, Sod Poodle fan #1 at the TYLA quarterly board meeting in Amarillo. The evening dinner and social was at the Sod Poodles Park, where Chris Rampelmeyer was in all his Sod Poodle glory. It was a great evening, but I apologize for those of you who I saw along the way that we did not take a photo together, but thank you for doing what's important. Remember, these quarterly board meetings that we have are merely pit stops in our journey in service to the profession as representatives of the profession to the State Bar and as representatives of the State Bar to the profession. So thank you for doing what you're doing and keep on keeping on. I want to talk a little bit about that solo small firm CLE that occurred yesterday. It continues our long practice of holding CLEs in the city in which we hold our quarterly board meetings for solo and small firm practitioners in advance of our board meetings. That occurred yesterday, which is September 26th, yesterday afternoon, here in Lubbock, in this room, as I mentioned. And I do want to thank the directors who participated along with myself as speakers at that event, and that would include our chair, Paul Stafford, Matthew Hill, Christy Castle, Lawrence Morales, and last but certainly not least, Judge Jerry Bullard. So thank you very much for making the time, taking the time to do that. The attendees learned about a variety of topics, including State Bar programs and resources. They enjoyed a primer on the new business courts and 15th Court of Appeals. And they heard updates on family law, personal injury litigation, and employment law. The final segment of my presentation, as I said, I'll be passing the virtual gavel to past President Sylvia Barunda Firth, who's going to bring us up to date on the efforts of the Building Planning Special Committee.
Good morning, and thank you, President Benish. Before I start, I want to take a little personal privilege and also thank Ray for his service. He's been working very hard with the building committee, and I hope that wasn't the reason he decided to jump out and retire, because it's been a lot of work. And I really want to thank Ray. Ray was the first person I ever spoke to when I set out to venture into State Bar leadership. And I've spoken with him recently and reminded him of that first phone call we had. And I want to tell him thank you and how much I hope he knows that he has been of credit to the profession and to the State Bar. Thank you, Ray. But on behalf of the committee, I'm here to give you an update with regard to the development of the 1450 Lavaca building. And we have 2 action items related to the project. We're continuing to work on pre-construction activities right now, and the staff is dealing with additional details related to the interior design and spatial elements of the interior portion of the building. The architect is now close to completing the construction documents. And as most of you know, the construction documents specify to the construction team exactly how to build the building and what elements go into the design. This includes things like textures, flooring, technical and system components, and many other specific building-related details. We're in the process of obtaining the building permit for the city, and that approval is expected to happen sometime in the next year. It's a long process. Our architect is getting close to finalizing our submission with the City of Austin. And we're working on obtaining updated cost estimates for the project. And we'll be working with the construction manager at risk to value engineer to see where we can maybe make some cost savings on materials and building construction elements. And regarding the fundraising, you've all heard about our work with FBC generosity experts, and those plans continue to move forward, and you'll hear more about those efforts in the coming months. But that brings me to my first request for an action item, and it's a recommendation from the committee that we ask the board to give us authorization to have the State Bar staff to continue to move forward with the design and construction planning.
Okay, we will entertain such a motion at the conclusion of your report, if that's okay with you.
Sure, that's fine.
Yeah, we're going to entertain that motion after you complete your report.
Okay, and then the next thing we would like to update you on is the acquisition of the selection of an owner's representative for the State Bar. An owner's representative is an industry expert hired by the owner of a building or a facility project to act as the owner's advocate and represent their best interests. The owner's rep makes sure the contractor meets the owner's needs by keeping the project on track, managing risk, ensuring quality throughout the construction, and preventing and minimizing cost overruns and change orders. And I do want you all to know that even governmental entities that have staff to engineers, whole departments full of engineers and public works people do hire an owner's representative on major projects. It's a common practice for owners to hire companies to perform these services, and they're useful, will be useful in our circumstances as they will provide technical expertise and guidance to our staff and be an extra set of hands to move the project forward in the next step. In order to do this, the staff initiated an RFP process to look for companies that might be interested in our building project. The RFP was posted on our website and was sent to 16 different companies who perform these services. We received 3 responses to the RFP, and all 3 were interviewed by the staff on September 16th. The 3 bidders all had relevant experience to perform the service, and staff made a recommendation to the Building and Planning Committee to select an entity called Square One, which is an Austin company that was founded in 1995. They were selected for a variety of reasons, and I'm going to highlight a few of them for you here. They have experience working with the state and are familiar with state processes and procurement. In fact, they're currently working on the buildings that are directly across the street from the Law Center under construction right now. They have significant experience working on buildings with owners who are undergoing capital campaigns, just like us. And the average hourly rate for Square One was lower than the other 2 bids we received, but Square One's overall cost estimate on paper was higher because they contemplated in their bid that they would have 6 employees working, and so consequently more hours on the project. The other 2 companies just contemplated using only 2. So the staff intends to negotiate with them to lower the number of employees that will be working on the project, which will lower the overall cost. We believe that using Square One will help us identify cost savings in our construction project and help us minimize change orders. They have a strong focus on team coordination and avoiding duplication of effort between the architect and the contractor. They have a hands-on approach with frequent presence and weekly meetings with all parties. So our second recommendation coming from the committee is that the board approve the building committee's recommendation to select Square One to act as the State Bar's owner representative for the 1415 Lavaca building. And that concludes my report.
Thank you for your report. We'll now entertain a motion to authorize the State Bar staff to move forward with design and construction planning as indicated in Sylvia Firth's report. Is there Director Castle? Okay, do we have a second? Second by Director Perez. Is there any discussion regarding the first of the 2 motions, which is having the State Bar staff to move forward with design and construction planning? Hearing none, all in favor of the motion signify by the sign of aye. All opposed? The ayes have it. We'll now consider a motion to approve the Building Planning Special Committee recommendation to select owner representative. Director Quadros? Is there a second? Director Cherry? It's been properly moved and seconded. Is there any discussion? Hearing none. All in favor of the motion signify by the sign of aye. All opposed? The ayes have it. Are there any questions based on the report from Sylvia? Thank you so much. And are there any questions for President Benish?
Hearing no questions, that ends my report, Chair Stafford. Thank you.
Thank you both so much. Okay, we've got two folks that have joined us by Zoom for public comment. And we're going to go to Tevia Bell at this time by Zoom. Ms. Bell, you have 3 minutes. Oh, if you could unmute, that would be great. Ms. Bell, if you could unmute, that would be great.
Hello, my name is Tiaga Bell. I was calling in to speak on behalf of the motion as it relates to Judge Morris in her application for the state bar. Is that this topic?
Yes, ma'am. You have 3 minutes to address the body.
I'm calling to speak on that motion or that vote that you're going to have today because I'm one of the people that is applying or is taking the test this year, but y'all have the rule that allows for judges to take the test, but you don't have any standards. So it allows for total disparity in the outcomes. Last year, when I first applied to take the test, like Judge Morris, I was denied initially on my first application. But in comparison to my colleagues who also had applied at the same time, although Harris County is bigger in the legal community, in some fields it is smaller. And to be initially told no, despite the fact that I had more criminal trials as a prosecutor and as in my 10 years as a public defender than would fill the page or I could even count, and that I'd handled some appeals and even done some things on the bench and tried God knows how many cases as a judge, the original answer was no until a hearing. Unlike Judge Morris, I took the no until I did the little appeal, but I didn't pursue keeping on studying and I didn't. To watch somebody who is in that position with a standard that allows for you to apply, but there is no standard whatsoever, it allows for arbitrary decisions like the one in this one. And when you're sitting there and listening to a meeting in which it's pointed out that there are two people that applied, one has more experience, and they said they weren't aware, but they don't, despite the fact, they don't discount the fact that you have two applicants that are similarly situated. You have both of them that applied at the same time. You have one that received an email that says, hey, apply under this prong, and one that did not. The one that did not was told no. The one that received the email received 30 days to apply under a different standard, and then a yes. And when the disparity was pointed out, what was said was, well, we've made a decision. And if you make a decision and the decision is not reflective of what is fair and what is equitable, you don't stand by the decision because it's one you made. That is not who we are. If we see an active disparity, we have an obligation to make sure that we clear that up, to make sure that we afford everyone the same opportunities. And in this one, it's wrong. And for us to stand by as a bar to a decision that is disparate because it's one we made is unacceptable. It'd be one thing if you said I compared, and upon comparison, that just wasn't the situation. But it's another one I won't even compare because we've said what we said. That is not who we are. That's not who our organization should be, and it should be better. Additionally, if you don't
Ms.
have
Bell, we
standards,
appreciate your time and your willingness to speak here today, and unfortunately, that is your 3 minutes.
thank you very much.
Thank you very much. We'll now hear from Veronica Nelson, joining by Zoom. You'll have 3 minutes to speak. Please unmute.
I am unmuted. Thank you guys for giving me the opportunity to speak. Just like Judge Bell, I am speaking on behalf of Judge Morris. I would just like to say I've applied 3 years ago. I was told I wasn't ready to take the test. I didn't have enough qualifications, so I applied again the following year, and then I was allowed to take the test. I say that because Judge Morris and I have exactly the same resume, except for she has a little bit more, but since she was a defense attorney. Judge Morris and I came out at the same time. We've done the same amount of trials. We've done the same amount of search warrants, and currently we are both judges on the bench for the same amount of time. And somehow I'm allowed to take it and she is not allowed to take it because of experience. But she has the same experience, if not more, than most of the people that I know that not only have taken it, but have also passed it and are now board certified and are practicing in the Houston area. I say that because Judge Morris, even though she has been told no twice at this moment, she is still studying with me and Judge Bell as if she is taking this test. We take practice tests daily. She does essays daily. She does multiple choice daily with the idea that she is ready to learn. And that's the type of person that we should be wanting to be board certified. She is a judge in Harris County, and she is going to be a judge for a very long time. Those are the type of people that we need to be board certified on that bench that are making those decisions every day. Judge Morris not only has the amount of time in terms of trials for misdemeanors, trials for felonies, but she actively every day does post-conviction work when she's dealing with motions for new trials, when she's dealing with appeals, when she's dealing with findings of facts. She does the work that is necessary, and she is overly qualified to at least have an opportunity to take this test, let alone to be board certified in her position. So I asked this bar and this board to look at her qualifications, not only on the bench, but all the things that she's done off the bench, to allow her to give her the opportunity to take this test because she has not stopped working for it. Thank you. Bye.
Thank you, Veronica Nelson. Hearing no other public members or public comments, we will now hear from President-elect Santos Vargas.
Thank you, Mr. Chair. Good morning, everyone. I know we have a very busy agenda and lots to do today, so I promise to be brief. Since the State Bar annual meeting in June, I've been busy supporting the lawyers and serving the lawyers of the state of Texas, our executive leadership team, and our current president, Steve Benish, and our current board chair, Paul Stafford, who I will say are doing a tremendous job leading this board. Thank you, and kudos to both of you, amazing leaders. I've been to a number of events in recent months, but there are really three that stand out. The first one was an event that we held in San Antonio, and it was a final send-off for Jimmy Allison. Jimmy Allison served as the executive director of the San Antonio Bar Association for more than 50 years. And we held a final send-off for him, his final walk out of the courthouse very recently. And let me tell you, Jimmy was an institution in San Antonio's legal community, and San Antonio showed up to support Jimmy on his final walk out of the courthouse. There were literally hundreds of people, hundreds of members of the San Antonio legal community that showed up to support Jimmy, and I was so honored to be there along with other members of our community, including Director Toscano and Director Morales, and so proud of Jimmy and all of the work that he's done for our legal community. Also had the opportunity to attend the annual gala for the Mexican American Bar Association of Dallas, where I was honored to be the keynote speaker. And last but not least, I was able to attend the San Antonio Bar Association's annual meeting and past president's luncheon, where I had the opportunity to watch my amazing wife, Patty Vargas, be installed as the president of the San Antonio Bar Association I couldn't be prouder of her. And for the next year, I will proudly bear the title of First Gentleman of the San Antonio Bar Association. I'm looking forward to a busy few months doing some good work for the State Bar, including work with our State Bar's Budget Committee. And the Budget Committee held its first meeting on Tuesday, September 3rd. The committee discussed the State Bar's budget process and the fiscal year 2025-2026 budget preparation timeline. Budget planning and projecting has been underway since August. Initial budget packets will be provided to the State Bar's division and department directors by October 1st, with a deadline completion date of October 11th. Once the budget data is received, the finance division will then prepare and analyze the proposed budget, and the budget review process will continue to include a step for review of compliance with the State Bar's limitations as set forth by Keller, McDonald, and the Boudreaux opinions. Also, the Budget Committee is going to continue the prior year's leadership initiatives on long-term planning from the bar's financial trends and projections, and the Budget Committee will meet again on December 17th at the Texas Law Center. Division and department directors will attend this meeting to provide information about their area of the budget, and during this meeting, the committee will finalize a proposed fiscal year 2025-2026 budget for a presentation to the Executive Committee and the board at the respective January 2025 meetings. Also have an update on the Committee Review Task Force. This year, a Committee Review Task Force has been appointed to review the bar's standing committees. It's made up of board members and members of the Executive Committee. Specifically, those members include Matt Hill, Lowell Kegg, Laura Pratt, Drew Spaniel, and I, of course, serve as the chair. The State Bar Act requires the State Bar Board to conduct a comprehensive review of the standing committees biannually to determine two things. One, whether there's a continued need for each committee, and two, whether there's unnecessary overlap of committee activities. The task force will meet with each of the committee chairs and review the activities of each committee over the past 2 years. We'll also look at board policy to see if any amendments should be made with respect to those committees, and the committee review process has led to some positive changes in past years to the standing committee structure, and we look forward to another thorough review by our committee review task force. Our goal is to complete our final report by the April 2025 board meeting, and we'll outline our recommendations to the executive committee and the board at that time. And with that, Mr. Chair, that concludes my report.
Thank you so much, President-elect Santos Vargas. Any questions for President-elect Vargas? We'll now hear from immediate past President Cindy Tisdale.
Thank you, Mr. Chair. Good morning. I have a short report. I've been busy, but not nearly as busy as President Benesch and President-elect Vargas. I only want to talk about one place that I've been, because oh, what a time it was. As you all know, I have my professionalism in the law, what would Ted Lasso do speech that is kind of caught on fire, and I give that to many different groups. I was blessed and lucky enough to be asked to speak at the Alabama State Bar annual meeting to their bar and give my Ted Lasso speech. What I did not know at the time when I accepted was the keynote speaker the same day I gave my speech was Brendan Hunt, Coach Beard. Oh, see, yeah, there's some Ted Lasso fans in the room. And so I was blessed enough to be, not only to meet Brendan Hunt, I talked with him for quite a while. I sat by him at lunch. We shared pictures of our kids. I think we're besties now. He doesn't, but you know, it's all good. He does. But no, it was truly joyful for me to talk to him about my speech, and how I want to bring civility to the forefront in our profession. And because that was one of my goals this past year, is to bring civility to the forefront, talk about civility, and make sure we're all mindful of that. So that was a great way to cap off my year as that year. Yet that picture, they were introducing me to Brendan, and they're talking all about me. Well, she, nothing about him. And he just looked at me and goes, well, you sound kind of like a big deal. And I went, oh, I am a big deal. And we did this, and they took the picture. So that is all I'll talk about that. I only want to talk about one other thing. And as you all know, one of my other goals as president was to have the conversations about mental wellness for attorneys and how it should be a sign of strength to ask for help and not a sign of weakness. You all know that the bar, we partnered with BetterHelp.com last year. BetterHelp is offering 1 free month of counseling to every lawyer, judge, member of the law student division, and member of the paralegal division. It's 1 free month of counseling and the 15% off. It provides these benefits and much others to our membership. I'm very happy to announce that as of September 23rd, again, this went into place May 1st, but as of September 23rd, we've had 353 members sign up for therapy, and 1,049 sessions with attorneys have been held to help them through whatever problems they're going through to be a better lawyer and a better person. Very happy. Members have also rated it a 4.6 out of 5 stars, so I think our members are liking that. If you're interested, go to thetexasbar.com, sign in, go to the benefits page, and that's where you find the code to get the 1 month free membership of counseling and the 15% off thereafter. And Mr. Chair, that is my report.
Thank you, Past President Tisdale. Any questions for Past President Tisdale? Thanks again. We will now hear from immediate past chair, Kenan Lilly Wooten, to talk about her nominations and elections report.
Hello, everyone. I'm happy to report that the Nominations and Elections Subcommittee is soon going to begin the search for the next president-elect candidates of the State Bar of Texas. It's hard to believe that the moment has arrived. This is a small county year, so that covers every single county in Texas except for the 5 metropolitan counties, which are Bexar, Dallas, Harris, Tarrant, and Travis. We did have our first subcommittee meeting on September 24th, and I want to say thank you to everyone who participated because it was a pretty extensive meeting. It took a lot of time and thought, and I really appreciated the discussion. So in the near future, immediate past president Cindy Tisdale and I will start reaching out to the individuals we identified as potential candidates to see whether they're interested in being considered further. We plan to conduct interviews of individuals in December, and then we bring to the board our recommendations in January. And after the individuals who will be the candidates are approved, they can officially start campaigning. The campaign timeline has been significantly shortened, and I think everyone's happy about that. So this time, there will be just less time on the road, and we'll see how that plays out, but I think it'll be positive. The other thing that I want to just mention, and I guess reiterate because it was already alluded to earlier, is that a third of our board as third-year directors will not be here after this bar year. So in order to make this process as thoughtful as it can be, to have people here who are really committed to service, it's good to start thinking now about who would be good to replace you. And I think this is a call to action for all of us, not just for the individuals who will be leaving, but the individuals who are here who know people who would be good to serve, not just because they've been real active in the bar, but because they have good hearts, they're service-oriented, and we think they'd be good sitting here and making decisions on behalf of the State Bar of Texas. So anyone who's interested in running for director or as president-elect can find information on the State Bar website or call the fearless Jennifer Reams in the executive office. The voting period, as we probably remember, will be April 1 through April 30th. And I just want to let you all know, as well as I conclude these remarks, that our subcommittee is also looking at other potential changes to the process, including in balloting and other things. And so we'll come back to you after more discussion about those things. If you all have any comments, questions, or concerns after today, you can reach out to me or immediate past president Cindy Tisdale. Thank you.
Thank you, immediate past chair Kenan Wooten. Any questions? Thank you for your report. Checkout time is at 11. 11. So we're going to take a break. We're going to take a 15-minute break, and we will be back here at 9:46. And if you need to bring your bag down, there's the wall to my left, your right, by the drinks that you can place them. We are now on break. Give a guy a gavel. Thinks he owns the world. All right, let's get started. Thus endeth the break. Before I call Director Liz Cantu to the podium, I'd like to be clear about a couple things. To avoid any confusion, after Director Cantu gives her report, we're going to hear from Senior Justice Learman and Justice Busby. Following their remarks, Director Cantu will return to make the motion on behalf of her administration committee and their report, and there will then be an opportunity for any discussion on the matter by our directors. Please identify yourself before any comments are made. I want to also announce, to be clear, to avoid any questions about what will happen, that the State Bar staff will be sharing directly with the Texas Supreme Court all comments from this meeting today from the public, which you've heard, and from directors, as well as any emails the board has received regarding these proposed rules. With that, I'd like to call on Director Liz Cantu as chair of the Administration Committee.
Good morning, everyone. I can't tell you how happy I am that it's me who's giving you this report. I'm honored and so pleased to be working with the Administration Committee. So I wanted to report that on October 24th of 2022, Justice Brett Busby of the Texas Supreme Court, in his capacity as liaison to the Texas Access to Justice Commission, sent a letter to the commission requesting that it examine existing rules and propose modifications that would allow qualified non-lawyers to provide limited legal services to low-income individuals. The commission formed a working group, which, along with 3 subcommittees that it formed, met several times and studied issues extensively. The working group issued a report and made recommendations to the commission on December 5th of 2023. The commission then met on December 15th of 2023, and at that meeting unanimously approved, with some abstentions, the working group recommendation regarding limited legal services by non-lawyers. After considering the report and recommendations on August 6th of 2024, the Texas Supreme Court issued an order titled Preliminary Approval of Rules Governing Licensed Legal Paraprofessionals and Licensed Court Access Assistants. The court is requesting comments about that order and the proposed rules. And so I am clear to everyone here, this body does not have decision-making authority. What we are hoping to do is to seek recommendations that we then give to the court for its consideration. The court's preliminary order envisions that the State Bar will be responsible for the regulation of legal paraprofessionals and court access assistants. The State Bar's executive staff and legal counsel immediately consulted with department heads and other key staff to carefully review the order in the interest of public protection and regulatory efficiency. Our committee had a brief call on August the 7th to discuss that order. The committee later met on August 13th to further discuss the order, and I reported all of the developments to the executive committee at its meeting on September 5th, 2024. The executive committee voted at that meeting to recommend the administration committee continue to review the order and to prepare a report and possible comments to be presented to the board at this meeting for its consideration and for comments from the board to the court. The court has asked for comments by November 1st. So this is the opportunity that we have to give our comments before that deadline. In addition, the Affordable Legal Services Committee met on September 12th to consider and discuss the order as well. Considering all input from State Bar staff, legal counsel, the Affordable Legal Services Subcommittee, members of the bar, and all other feedback brought to our attention, I worked with our legal counsel on a draft of comments to propose to the board for its consideration. On September 13th, our administration committee met to discuss the red line draft of the proposed comments, And in addition to our State Bar leadership team and executive staff, we were honored to have Senior Justice Lehrman and Justice Busby attend our meeting to discuss the topic and to be available to answer questions. We had a valuable discussion. Ultimately, the Administration Committee voted unanimously to recommend the changes shown in the following red line that I will discuss momentarily for the board's consideration, and the red line will be projected up above so that you can follow along. But before discussing the proposed changes or comments, I wanted to overview the content of the court's order. It proposes new Articles 15 and 16 of the State Bar Rules and proposed amendments to the Texas Rules of Civil Procedure 500.4 and 510.4. The proposals include the following notable changes. Under Article 15, titled Licensed Legal Paraprofessionals, it defines the roles, the responsibilities, and the limited scope of licensed legal paraprofessionals practice, specifically for those clients who qualify as low income, defined as at or below 200% of the federal poverty guidelines as published annually by the U.S. Department of Health and Human Services. It also establishes standards and procedures for their licensure, ensuring that they meet certain qualifications, including educational qualifications, examinations, good moral character and fitness, and ongoing training, and adhere to ethical guidelines and standards for professional conduct, including client confidentiality and avoiding conflicts of interest. It also limits the legal services of paraprofessionals to practicing with or without lawyer supervision in 3 areas of law: family law, estate planning and probate law, and consumer debt law. It also allows licensed paraprofessionals to practice in justice court. This article also provides for oversight and regulation of licensed paraprofessionals, including court sanctions and discipline of paraprofessionals in the event they violate any provision contained within Article 15. The regulatory scheme is to be administered by the State Bar. Article 16, titled Licensed Court Access Assistants, defines the roles, responsibilities, and limited scope of licensed court access assistants supervised by a lawyer at a sponsoring approved legal assistance organization, such as legal aid organization or a clinic or pro bono program of a Texas law school. That article establishes standards and procedures for licensure which are less stringent than those for licensed legal paraprofessionals, since they are to be provided less freedom to practice on behalf of low-income clients, and they are to be supervised by a lawyer and sponsoring approved legal service assistant program. Article 16 also sets out the obligations of the sponsoring approved legal assistance organization and prohibits licensed court access assistants from charging for their services, since they are paid directly by their sponsoring organization. The rules of law and evidence relating to privileged communications between lawyer and client also govern communications made or received by a licensed court access assistant and their low-income client. The preliminary order also makes changes to the Texas Rules of Civil Procedure as follows. It amends Rule 500.4 regarding representation in justice court cases to allow representation by licensed legal paraprofessionals and licensed court access assistants pursuant to the State Bar Rules. It requires the non-attorney to provide notice to the court and to all parties as to the scope and limitations of their limited appearance. It amends Rule 510.4 regarding issuance, service, and return of citation to include a sentence informing individuals to consult with the amended rule about their rights regarding representation, either by themselves, an attorney, or a non-attorney. The Supreme Court has requested comments regarding the new and amended rules, and that they be submitted in writing to the following email: rulescomments@txcourts.gov by November 1 of 2024. The following are the changes that we propose that you consider for approval as comments to be provided to the court on behalf of the board by November 1st of 2024. Okay, on page 3, section 2, The proposed changes would enhance the educational level of paraprofessionals from the order as it was issued to require an associate degree, and it would prohibit currently disbarred attorneys from being eligible for licensure. This would better protect the public. On page 4, section 3.A, the proposed change would allow applications to be submitted as directed by the State Bar, rather than being submitted to the State Bar. This change was made after considering the long history of how the Texas Board of Law Examiners, or TBLE, has handled attorney applications, and after we talked about it with the TBLE. It also adds language clarifying when application fee and licensure fees are due to align with the State Bar's current existing procedures in place for attorneys. Page 4, section 3.C, this proposed change would clarify that licensed legal paraprofessionals are enrolled as limited members in the State Bar, whose rights and privileges are defined in the order, unless stated otherwise or established by further order or rule or bar policy. Page 5, section 5B, this proposed change would allow the TBLE, rather than the State Bar, to conduct assessment of character and fitness. TBLE has always done this for attorney applicants, and the State Bar does not have the means to handle this process. Page 5, section A1 and section A2. These sections include proposed changes that clarify that the TBLE will direct the administration of the ethics and subject matter examination for applicants, not the State Bar. Page 6, section 6E. Similarly, the current requirements that prohibit someone who has failed either the ethics or subject matter examination 5 times from being licensed unless they have been granted a good cause waiver. Since the TBLE is directing the administration of the exams, it makes the most sense for the TBLE to be making these good cause determinations, as they already do for attorneys. Page 6, section 7B. The permitted practice section explains duties owed to clients by paraprofessionals. In the interest of public protection, the State Bar recommends the following 4 changes to that section. Change number 2 would be adding provisions to the engagement agreement regarding the client's rights and how the relationship can be terminated, and this would enhance public protection. Adding number 3, this change would require the paraprofessional hold in trust any fees or payments until the legal paraprofessional confers a benefit on the client or performs a legal service for the client. Adding number 4, this change would require the paraprofessional promptly notify a client upon receiving funds or other property in which a client has an interest. Also, in promptly delivering to the client any funds or other property that the client is entitled to receive, and upon request by the client, promptly rendering a full accounting regarding such property. Adding number 6, this change would prohibit paraprofessionals from receiving a percentage fee, a contingent fee, referral fee, origination fee, or a fee that is illegal or unconscionable. This change was made because lawyers already provide services, and there is no justice gap in representation of poor Texans in areas of law where lawyers already represent clients by means of a contingency fee agreement. And having paraprofessionals involved in referral fees could cause unforeseen harm. Moving on to page 7, section 7D1A. This says that in an uncontested divorce matter, paraprofessionals can advise a client on completing and filing family law forms. The red line just recommends adding language to clarify that paraprofessionals can advise a client on how to complete a form, and the paraprofessional may file those forms as improved language. Page 7, section 7D2. Regarding quadros or qualified domestic relations orders, only lawyer review was previously required for a licensed paraprofessional to prepare a quadro. The proposed change would require formal lawyer supervision and would require the lawyer to be identified in filings to safeguard this work. Page 8, sections 7D3A. This says that in an uncontested suit involving children, paraprofessionals can advise a client on completing and filing family law forms. The red line just recommends adding language to clarify that paraprofessionals can advise a client on how to complete the forms, and the paraprofessional may file those forms as improved language. Page 8-9, section 7E1 and 7E2 and 7F1. These sections, like those above, are changed to clarify that paraprofessionals can advise a client on how to complete a form, and the paraprofessional may file as improved language. Page 11, section 9E. Section 9 sets out the code of ethics for licensed legal paraprofessionals. The red line change would add a provision to 9E requiring that paraprofessionals keep a client reasonably informed about the status of a matter and promptly comply with reasonable requests for information as required by lawyers under Rule 1.03 of the Texas Disciplinary Rules of Professional Conduct. Page 11, section 9G. Similarly, the renumbered and redlined section 9G revises the language regarding conflicts of interest to mirror and/or require paraprofessionals to comply with Rules 1.06 through 1.09 of the Texas Disciplinary Rules of Professional Conduct. Page 12, section 9H. This proposed change would prohibit paraprofessionals from knowingly making a false statement of material fact or law to a third person, and additionally prohibiting them from failing to disclose a material fact to a third person when disclosure is necessary to avoid making the paraprofessional a party to a criminal act or knowingly assisting a fraudulent act be perpetrated by a client. Page 12, section 9I. This change would require licensed legal paraprofessionals to follow the advertising rules in Section 7 of the Texas Disciplinary Rules of Professional Conduct, as if legal paraprofessionals are governed by those rules. Page 12, Section 9L. As a final tweak to the Code of Ethics, in order to safeguard clients from the possibility of fraud or other financial loss as a result of a paraprofessional mishandling client funds, the proposed change would require licensed legal paraprofessionals' practices to comply with Article 11 of the State Bar Rules and Rule 1.14 of the Texas Disciplinary Rules of Professional Conduct as if legal paraprofessionals are governed by those rules. Page 13, Section 10, B, C, and D. Moving on to paraprofessional discipline. In order to streamline the complaint process, the State Bar advises revising language in these sections as shown to allow the State Bar to develop procedures needed to effectuate the rules. Page 13, sections 10E and 10F. The proposed changes in these two sections would allow the State Bar to not only suspend or revoke paraprofessional licenses, but to permit in appropriate instances conditional licensure to address the many instances such as substance use disorders and mental health disorders where it is appropriate to allow licensure so long as appropriate conditions are met. Page 13, section 10F. This change proposes adding language directing disciplinary appeals to be submitted to the Board of Disciplinary Appeals, BODA, rather than the executive director of the State Bar, because the State Bar Act makes clear that the executive director is not empowered to be involved in the disciplinary process under the Texas Government Code Section 81.029. Likewise, and for the same reason, Section 10F1 is proposed to allow paraprofessional appeals to be heard by a staff attorney designated by the Chief Disciplinary Counsel rather than by the executive director of the State Bar or his or her designee. Pages 13, 14, sections 10G. The final red line changed to paraprofessional discipline proposes aligning the procedures for paraprofessional disciplinary appeals with the current procedures for lawyer disciplinary appeals. This change would also require that the Texas Rules of Appellate Procedure apply to those appeals. Page 14, Section 11, under annual licensing requirements, because the rules require less stringent educational requirements for paraprofessionals than those required for lawyers, and to alleviate the complications to the State Bar CLE regulation system caused by different guidelines, the bar recommends revising the number of required CLE hours under Section 11B2 to 15 hours, 3 of which must be ethics and 7 hours self-certified in each subject matter of licensure. 11C is also revised to align with the attorney MCLE compliance year for operational purposes. 11D aligns with the annual dues deadline that attorneys have. Page 15, Section 2B, moving down to the proposed changes regarding licensed court access assistants. The proposed change would require all licensed court access assistants to be at least 18 years of age. And under page 16, Section 3A, similar to paraprofessionals and because of the substantial costs anticipated without any additional budget funding, the State Bar recommends revisions to Section 3A under this article to allow the possibility of fees as set by the State Bar with the approval of the court. Page 16, Section 3C. This proposed change would clarify that licensed court access assistants are enrolled as limited members in the State Bar, whose rights and privileges are defined in the order unless stated otherwise or established by further order, rule, or State Bar policy. Page 16, Section 4A. The proposed changes would require court access assistants to inform clients that they are not a lawyer, but are being supervised by a lawyer. And in the required written consent from their client, it must include a disclosure of the name of the supervising lawyer in order to safeguard lawyer supervision. And finally, pages 17 and 18, as you see in the red line sections 5, 6, and 7, under licensed court access assistants, additional minor red line edits are included in the attached regarding Article 16 for licensed court access assistants for the same or similar topics as covered above for paraprofessionals. And this concludes my report.
Thank you, Director Cantu, and we will now hear from either Senior Justice Lehrman or Justice Busby.
Good morning. Thank you, Mr. Chairman and Mr. President and Madam Chair. We appreciate the report, and I appreciate the opportunity to be with you today. I don't normally get this opportunity, so I just wanted to take the chance to say thank you to each of you for your volunteer service to help lead our profession. You've heard from Director Cantu about the need that we're addressing with this order, and so I won't go into great detail about the items that she's already discussed and that you can read the working group report for a lot more detail on that process. But suffice it to say that that low-income Texans the vast majority of them are not able to get help with their needs for basic civil legal services. And traditionally, our bar has tried to address that through helping to increase funding for legal aid through appropriations and donations, and also through pro bono work, which is vital. And I know that so many of you participate in that and have helped a lot of Texans who really need it. But the need is nonetheless growing. And so we've looked, as the order says, for creative solutions to help continue to address that need. And we went through this working group process that Director Cantu has mentioned, and I want to thank the State Bar for its support of that process, and also want to give particular thanks to Ken Wooten, who was one of the co-chairs of our working group, and to Harriet Myers, the chair of our Access to Justice Commission, who's here, both of whom were very involved and spent countless hours in that effort. And we had great participation from across the bar. I want to particularly thank the sections that partnered with us to look at the issues of which areas we should be focusing on, what are the areas of greatest need, where we see the most self-represented people coming into the court system, and they're the ones that have been mentioned to you. family law, landlord-tenant, consumer debt, and probate. That's where we see the most self-represented people in our courts. And so each of the sections that works on those issues are interested groups of folks sat down with us, became part of the subcommittees that we're looking at, let's have a dialogue. What are the simple issues that can be handled in uncontested matters? In a lot of these courts, it's in uncontested matters where it's simple enough where a properly trained, licensed paraprofessional who's passed an examination can provide adequate representation at a lower cost. And so I want to thank the family law section, Jonathan Bates, Chris Nicholson, Chris Rampelmeyer, the probate section, the consumer section. Also, I want to thank the immigration section for their comments. As you heard, we have made clear that this does not apply to immigration services. It's only in the areas that I mentioned, so that these paraprofessionals are not going to be showing up in immigration court. They're also not going to be showing up in bankruptcy court. I saw that there were some comments submitted on that, and we can certainly make that clear. This is for debt collection cases outside of bankruptcy court. So we're not proposing that these licensed paraprofessionals or court access assistants will have any role in any federal tribunals. That's obviously outside of our mandate. And I want to make clear that there are two important limits in here. There's an income limit for the people who can be served. There's also a subject matter limit, as I've said, very narrow areas that with the consultation of the people who are experts in this area from the sections have helped us define those limited areas where paraprofessionals can provide quality representation to people who are not currently being represented by lawyers. So this is additive in the court's view. It's not, this is not taking away clients from anybody who's serving them now. This is a way to serve people who are not currently being served. And actually, they've found in the states that have done this already, in Arizona and Utah, and also for decades, they've had a program like this in England and in Canada. And actually, oftentimes, the paraprofessionals will work with law firms to do this, and it enables the lawyers then to serve a segment of the market that they were previously priced out of. So that's a little bit of the information. The satisfaction also, it was mentioned a question about getting feedback about how this is going. We completely agree with that. There's a provision in there that the State Bar will approve a brochure that paraprofessionals have to provide to their clients so that they can provide feedback and file any complaints. It's been great, actually, in Arizona and Utah. They've been collecting detailed information, and the satisfaction rates are extraordinarily high with these programs. I think they've had one complaint in both states the whole time the program's been operating. So actually, some people have said, we like them better than lawyers. But, it's, again, and this is just for limited legal services that lawyers are not currently performing. And because it's very simple things that paraprofessionals will have the experience to do and have been examined on, that's why I think you're seeing those results in those other states. So I just want to mention, thank again Chair Cantu and her committee. I think a lot of what you've seen this morning is a great effort. I want to thank Trey and Chris Ritter and the staff because they've worked hand in hand with the administration committee on identifying how can we make this work better, how can we make it easier for the bar to administer. We appreciate the bar being willing to step up and help make this program work. And so I know the court will very favorably consider any comments that we receive from the bar along the lines that the committee has proposed. I did want to mention Steve Bresnan's question. I thank him for that, and I'll refer you to page 7 of the working group report, which addresses the court's authority to promulgate rules. That is something that we looked at, and I think I will stop there unless there are any questions.
Thank you, Justice Busby. We're going to bring Liz Cantu back up, and she's going to make a motion on the Administration Committee's report on proposed comments, and then we'll have an opportunity to discuss and provide comments from our directors.
So having been unanimously approved by the Administration Committee and on its behalf, I move that the Board of Directors approve the proposed changes shown in the red line, just discussed as comments to be provided to the Texas Supreme Court on behalf of this board by November 1st of 2024.
Coming from a committee, it doesn't require a second. Is there any discussion regarding the administration committee's proposed comments? If you are making a comment as a director from the microphone, please identify yourself.
Director Rudy Mateer. Mr. Chair, I'd like to move to executive session to seek legal counsel on item 12.
Okay, there's been a motion to move to executive session. Yes, understood. At this time, which is 10:17, we will move into executive session.
Yeah, because they still need to hear all of us.
We are now out of executive session. No action was taken during executive session, and we're going to resume the open session. Recognizing those that wish to speak regarding the motion to approve the Administration Committee's proposed comments regarding Texas Supreme Court's preliminary approval of rules governing licensed legal paraprofessionals and licensed court access assistants to be submitted to the Supreme Court on behalf of the board before the November 1st, 2024 comment deadline. Director Courageous, you are recognized.
How's this?
There you go.
Very nice. My name is David Courageous. I am a director from Austin. I apologize for the microphone, but I am admittedly conflicted on this.
If you want to approach and use this microphone, and please don't break it. It's the last one we got now. We got one left.
I apologize for Director Mateer's actions, and I further apologize for President Benish for refusing to do this on multiple occasions in Lubbock. Nonetheless, my name is David Courageous. I'm a director of the City of Austin, and I admittedly have conflicting thoughts on this issue. One, from a public policy standpoint, in that this issue has been brought up many times before in the legislature, and many times before the legislature has declined to see it through. The other side of that is I deeply respect the separation of powers and the wisdom of the Supreme Court and the efforts that they are trying to do to reach to expand access to justice, especially for low-income individuals. With that, I do have a few questions. One, regarding previous efforts made to expand access to justice involving licensed attorneys and making it easier and less costly for individuals, especially in low-income areas and backgrounds, to become attorneys, which would presumably increase the number of lawyers that we do have. And secondly, I have a request from my background in finance. Specifically, I think my page number was wrong, but it was, on mine, it was Section 7, Paragraph F, having to do with debt collection. The vast majority of individuals that I deal with are low-income individuals and do not engage in debt collection litigation, not because they do not know how to fill out forms, but because they are bullied, they are scared, and they do not have access to representation. An abnormally large number of individuals in the debt collection world are not attorneys, and it is primarily litigated on the JP court. And in my area of practice, the paralegal actually does most of the work anyway and advises. They just happen to have an attorney that is 10 feet away in case she has questions, and she never has questions. But the way it's written now, I don't believe is inclusive enough. The practice, especially for garnishments and receiverships, preys on low-income individuals who do not fight the debt that they are alleged to have. And especially in garnishments and receiverships, they've already been through the litigation process.
often without notice. They need actual representation in that in those matters, not just somebody to look over the forms. So for now, those conclude my thoughts, and I appreciate the time.
Thanks for your comments. Well taken. Director Charbonnet.
They said we're going to try this over here that's closer to the equipment. So I really don't have a dog in this hunt, really. Good thing for me is I am an elected JP in a county of 2 million plus people. I hear these cases that we're talking about every single day. And I will echo what you're saying is that a lot of these people don't have any type of representation because they can't afford it at all. As far as people being at the people being able to represent these individuals, I will ask the court as part of a comment is to make sure that whenever you talk about eligibility for the person to be able to do it, I know a bunch of ex-JP judges in huge counties that might like to be involved in this, but they may not fit the eligibility education requirements, but they've heard thousands and thousands and thousands of these cases that we're talking about. So make sure that when we talk about eligibility, we take in some sort of work history experience. What have you done? And we can't just redline it right at one specific area. That's all I got.
Thank you, Director Charbonnet. Not that you haven't done that, but a reminder to please direct your comments to the chair. Also a reminder, we haven't placed any time limits on comments. That's a deference to you and the fact that you know when you're being long-winded. And if you don't, then you'll be reminded of that. So additional comments regarding or discussion regarding the motion regarding the comments? Just please introduce yourself.
Chris Rampelmeyer from Amarillo, District Director. And when I heard the word long-winded, I felt that was a call for me to come up here. I want to first say that I appreciate the court allowing the family law section to have some input in this process. I will acknowledge that many of our members are bitterly opposed to this, but this is a matter at this time of trying to come up with something that is the best product possible. But I do want to acknowledge that. A couple specific points, and this just like when you read your legal brief over and over and over again and you see things that you didn't see before. In the section about family law, it talks about not allowing the paraprofessional to prepare quadros, qualified domestic relations orders. And I think we need to expand that a little bit to any kind of retirement division orders, because there are some specific federal and state plans that are, they say you may not call it a quadro. You may not call it a qualified domestic relations order. And I think the intent was to cover something more broadly. But I mean, I don't handle military retirement division orders anymore. They've gotten so complicated. So we don't want to end up opening a loophole.
I don't want to interrupt you, but I presume you're talking of Section 7.
Yes.
D as in dog.
Yes, and I'm sorry, I don't have that.
That's okay.
Right there.
Put it up
Sorry.
behind me.
I also want to my colleagues who are chairs, immediate past chairs and chairs-elect of the immigration law section, I want to say that I think their point about not allowing paraprofessionals to work on any cases in which there are non-citizens involved, not immigration, not specifically immigration issues, but where non-citizens are involved because these cases can have ramifications on non-citizens. I think that's a very valid point and a very important point. And finally, I would just note that in the many comments, there were comments about fee caps or fee regulations. And so I would just want to make sure that those comments are addressed by the court. Thank you.
Thank you, Director. Additional comments or discussion regarding the proposed comments from the Administration Committee? Please don't break that mic.
Director Mateer
Director
from
Mateer, you're recognized.
Austin, Texas. I just want to reiterate and comment to the public that's watching and those who are hearing and those who are trying to sleep at night so they listen to State Bar meetings, that our role here is not a role where, in effect, that we have a legal position on this. Instead, the Supreme Court asked us to give guidance and included our comments and concerns in here. Additionally speaking, what you've seen from this morning from Ms. Cantu is that there's been additional comments that were added and included here for that. So for those of you who have serious concerns or are asking about what we can do regarding this body right here, right now, our best opportunity right now is to try to see what we can do to make a discernible difference in hearing from your thoughts and getting input in here. With that said, I would say, Mr. Chair, I believe it's section 11B2 that speaks about the CLE requirements for the paraprofessionals. If I have that wrong.
Yeah, let's find it.
Okay. My concern is.
Just a second. It is 11B2. If we can get it on the screen, that'd be great. Page 14.
Oh, that would have been easier for me to say page 14, right? My only, oh, keep scrolling.
11B2.
There we go. My only concern is that we, something that was Ms. Cantu said is that there's 7 hours of I guess what we do with self-identity, regarding self-study.
Self-study, correct.
Self-study. Is that, I didn't see that in there. I just wanted to make sure there's no self-study, right?
I'm going to hand over to Chris Ritter.
Okay.
It's a good question.
Great question, and the original order said that they would be only required to, or the order as it stands, says that they would be required to have 3 hours of ethics and 7 hours in their subject matter. The bar has a pretty developed set of CLE. Our system is set up that it does not track which subject matter your CLE's in. And so instead of us spending a lot of money to track which topic and come up with a new thing on each CLE, we're just asking that they get 7 hours in their practice area, 15 total, but 7 in their practice area, but they self-certify that was in family law or in probate.
Excellent. Thank you.
Yeah, just to clarify, it's self-certify, it's not self-study. So I think that's the clarification on that, but great question. Any additional comments or discussion regarding the comments in the Administrative Committee's proposed comments? How many times can you use comments in a sentence? Okay. Hearing none. Oh, sorry,
And
Chris,
this
I
may
didn't see you.
Chris
Seeing that.
Rampelmeyer from Emerald, Director. This may be maybe a point of order or whatever, but I want to ask that we amend the motion to allow that it be qualified domestic relations orders or similar or other retirement division orders, and also to amend it to prohibit paraprofessionals working on any cases allowing in which non-citizens are a party.
I'm going to ask you to cite the provision. I think you're at section 7D, family law, on your first proposed amendment?
On the first, yes. If you go down just a little bit farther, yes.
Can you restate your proposed amendment?
Yes. So it would say, prepare a qualified domestic relations order, quadro, or any similar order required to make a division of retirement funds or benefits effective. To make a division of retirement funds or benefits effective. If not preparing such an order instead of quadro. Instead of a quadro, it'd be such an order.
Okay, your amendments are taken one at a time. What's your second
The
amendment?
Second Amendment is in general, not just in family law, but in any portion. And I apologize, I'm doing this on the spot, and
okay.
I really
Me too.
apologize. But in a general area that, and it may be where we go down to and we talk about, there's a prohibition on paraprofessionals practicing in the area of immigration law. So just a quick word search of immigration. Right. Maybe right there, we say a licensed legal professional may not provide immigration services or any services in a case in which there is a non-citizen as a party or as a client.
And what page is that? Is it 12?
And as a client, we'd address the probate part where you may not have a actual court case. And those are my proposed amendments.
Okay. We got to take them one at a time. But to be clear, again, it's section 9. J. Correct, Chris? Section 9J is your second amendment? Okay. Your amendment requires a second. So is there a second to the proposed amendment to section 7D, family law, which was the first stated amendment by Chris? Seconded by Director Perez. Okay. All in favor, is there any discussion regarding the first
I have a
amendment?
question.
Yes, Justice Learman.
So my question is to Chris. So are we talking about an ancillary document such as a quadro that would effectuate a division in the decree? Or are you also including, because the forms do have an area that deals with division of retirement. So are you just talking about the ancillary documents like a quadro that would effectuate that? Or are you including the decree itself? Okay, that's what I thought you meant, and that makes sense to me.
Okay, thank you, Justice Learman. Director Rappelmeyer's motion has been made and seconded by Director Perez. Is there any discussion can we go to page 7? It's right here. Paragraph 2. Never mind. When providing services under paragraph 2, the licensed legal paraprofessional must not, without lawyer supervision as defined in section 1F above, prepare a qualified domestic relations order, quadro, or any similar order required to make a division of retirement funds or benefits effective. If not preparing such an order, the licensed legal paraprofessional must advise a client to seek prompt assistance from a lawyer. Is there any discussion regarding the proposed amendment? All in favor of the proposed amendment signify by the sign of aye. All opposed? Okay. Moving to the second proposed amendment by Director Rappelmeyer. It requires a second, but we got to go to the page. I believe it's page 12. J, Section 9, Code of Ethics. J, A licensed legal paraprofessional must not provide immigration services or any services in a case in which there is a non-citizen as a party or as a client. It requires a second. Is there a second? Oh, Director Hill. Okay. Is there any discussion regarding the proposed Second Amendment? Director Courageous, please.
David Courageous, fine city of Austin. So I want to make sure that this isn't saying that lawful permanent residents can't be served. And if that's the case, it should be amended to allow for service of individuals who are lawfully residents of the United States and/or Texas.
Director Eppemeyer, do you want to speak to your amendment? We don't have an amendment to an amendment yet, but can you clarify the amendment that you were proposing? Please.
This is Chris Rampmeyer from Amarillo, Director. In my very quick instruction on immigration law a second ago, I understand there are two classifications of legal residents. I think this matter may require a little bit more consideration.
Are you withdrawing your amendment? You've already made your comment.
Yes, I have. So at this time, the only change I would make would be to say, instead of case, I would say matter, and I'm not able to address the point. I
Okay,
don't have
well,
the knowledge.
to make it procedurally clean, we
Yes.
have to vote the amendment up or down.
Okay.
Just to make it procedurally clean, without an amendment to your amendment, which we don't have. So.
Okay.
Is there any other discussion about the somewhat vague amendment? Justice Busby.
I just had an informational question for the movement so that the court understands what it is that we're being asked to do. I think there are federal law provisions that prohibit discrimination based on immigration status in, for example, in housing. And one of the areas that would be served here is landlord-tenant. So I'm wondering if there are any concerns about exposing paraprofessionals to liability for discrimination based on immigration status.
Okay, any additional comments regarding the Second Amendment? Yes.
I just, reading it, needed a clarification. The addition of, can we remove the box, the revision box there? Thank you. So a licensed legal paraprofessional cannot provide any services in a case in which any party is a non-citizen. And does that mean if a poor Texan is divorcing a non-citizen, that they may not get a licensed legal professional? If they are being sued by a creditor who's a non-citizen, they may not hire a legal paraprofessional to help them. It's the any party being a non-citizen for any service that causes me concern with regard to the breadth of the suggested amendment. Am I misreading that?
No, I think you're reading it verbatim. Additional comments regarding the Second Amendment? The second proposed amendment, not the constitutional Second Amendment.
Rudy Mateo, Director of Austin. Have we talked about permanent residents yet? Because those are they citizens under this, or are they considered non-citizens? Because that's another subject that if we're going down this route, we need to think about that too. Just saying.
Thank you for your comment, Director Mateo. Any additional discussion or comments regarding the amendment, Second Amendment? All in favor of the Second Amendment signify by aye. All opposed? I think the nays have it. Okay. Now we go to the motion. Motion was made by Director Cantu regarding the approval of the Administration Committee's proposed comments. It was amended as to Section 7D Family Law, which was approved by the body. Based on that amendment, we now restate that the motion for approval of the Administration Committee's proposed comments regarding the Texas Supreme Court's preliminary approval of rules governing licensed legal paraprofessionals and licensed court access assistants to be submitted to the Supreme Court on behalf of the board before the November 1st, 2024 deadline, as amended through Director Reppelmeyer's motion, as well as the second of Director Perez and approved by this body, is now subject to vote. All directors in favor of approving the Administration Committee's proposed comments, please signify by aye. All opposed? The ayes have it. Okay. Now, we're going to recognize Director Alex Stelly, who's going to provide a report on performance measures and strategic planning subcommittee.
The subcommittee has been meeting since April to prepare the board as we review the BAR strategic plan and performance measures for updates as required by state statute. The process officially kicked off in July at the board retreat in Houston. At our work session on July 24th, a professional facilitator led the board in a series of discussions designed to help guide the strategic plan updates. The retreat was very successful in generating discussions on how the BAR can best meet its mission, and I want to thank everyone for their participation and active engagement. The subcommittee met on September 18th to review notes from the board retreat and began the task of revising the strategic plan. We're trying to create a plan with much fewer goals so that we've been combining some. One of our objectives is to streamline the existing strategic plan to make it easier to follow while continuing to uphold the BAR's commitment to serving the public and our members. The subcommittee will hold additional meetings with the goal of submitting proposed updates to the strategic plan for the board's approval in January. After that, we'll begin working on revising the performance measures for review by the board in June. Thank you.
Thank you, Director Stelly. Any comments or questions for Director Stelly regarding performance measures? Now we'd like to recognize the Honorable Harriet Myers, Chair of the Texas Access to Justice Commission.
Mr. Chair, Mr. President, members of the board, thank you once again for having the commission here as your guests to speak with you. We value this time and appreciate being here. I'll begin by thanking the Supreme Court and the State Bar for the most recently appointed and reappointed members of the commission. Our membership is very important to us, and our newly appointed and continuing to serve commissioners, as you can tell by review, represent tremendous individuals in our bar and some public members who contribute very importantly to our work. We're very grateful for each of them and each of the work, all of the work that they do, and for the dedication that we see all the time to trying to meet the needs of the poor in this state who need representation and very sadly don't get it. Just to mention who have now served as new members of the commission. The first I want to mention is a reappointment of Roland Johnson for a 3-year term, who for the first time will also serve as vice chair of the commission. And Roland, of course, is not new to this board, nor new to the Access to Justice Foundation, where he also serves so admirably. So we appreciate greatly his service. The Supreme Court appointed also for 3-year terms Hillary Preston of Vincent and Elkins in Austin and Sandra Phillips Rogers of Toyota in Plano. Reappointed were Tom Leatherberry, now with the SMU Dedman School of Law in Dallas, Judge Nicholas Chu of Probate Court Number 2 in Austin, and Judge Latasha Lewis Payne of the 55th Civil District Court in Houston. So as you may recall, you, the State Bar, also give us such tremendous help in appointments, and newly appointed Dr. Glenn Burton is a CPA who joins us as a public member. He is the Vice Chancellor for Business and Finance and CFO at Blinn College in Houston. The State Bar also appointed Diana Perez Gomez of Chamberlain in Houston and Judge Penny Roberts, retired, of Tom Green County. One of our great sorrows this year, however, has been losing Kenan Wooten, who served so admirably on our commission for so long and was one of the 3 co-chairs of our special project, along with Lisa Hobbs and Justice Michael Massengale. The court also appoints an executive committee now of the commission to help us function. It's been a very important addition for us, and along with myself and Roland, who serves as vice chair. Judge Roy Ferguson, David McAtee, General Counsel of AT&T, and Terry Tottenham of Norton Rose, and Dean Brad Tobin of Baylor Law serve on the executive committee. You can see we have tried to focus that membership on some of our most important projects like veterans and law school work on access to justice issues. The commission seems to recently specialize in large projects. The obvious immediately preceding subject having occupied a great deal of our time last year. And this year, we have started an extensive strategic planning process for the commission, about which I know you've heard a bit, but an update on that work is that 125 individuals with expertise and knowledge have been invited to participate in at least one of the working groups to study the issues and help develop the plan for the commission. At this time, 85 different individuals have committed already significant time and will continue to serve with us. We had only 5 individuals who declined to participate, who were asked, we're sure all with good reason. The plan process involves 6 working groups, and they are as follows. The Court Access Group, that group is chaired by Judge Laura Livingston and Judge Melanie Wilkinson. We're grateful for their service. The Increasing Lawyers Group, really designed to increase pro bono and just what we've been talking about this morning. That group is chaired by none other than your own Pablo Almaguer, who, of course, was your chair. The Rural Access and Legal Deserts Group is chaired by Judge Roy Ferguson out in West Texas, and there is no one who would personally have the same degree of expertise in those issues than Judge Ferguson. The Resource Development Group and structure and organization for the commission area will be handled by the executive committee and with additional help as necessary. And finally, the Viability of Self-Help group is chaired by Roland Johnson. So we are hard at work, and the chairs have not only taken on their own groups, but they also now, we have brought them together to meet amongst themselves so that they can discuss procedures, the progress being made, and the timelines that are needed to get a strategic plan in process. We also are considering a number of other issues that were identified as not being able to be isolated to a group because they run through all of the groups. And those areas are technology, our law school partnerships, client involvement, and communications. So as you can tell, the strategic plan is moving along, and we are so fortunate to have the leadership and counseling and assistance from our liaison from the Supreme Court, Justice Brett Busby. And we very much appreciate his efforts when we know how much is on his plate all the time. I am very pleased to report about the Veterans Gala that will take place again this year. That event has become a regular, really highlight for the commission, and I believe the legal profession across the state as it tries to raise money to support legal help for veterans who can't afford lawyers. This year's event will happen April 30th, and we'll be at the Four Seasons Hotel this year. We're excited about that location, and we are so fortunate to have two co-chairs this year, both extremely dedicated to the success of this event, and those are David McAtee, again, as General Counsel of AT&T, and he has recruited Van Beckwith of Halliburton. The General Counsel there will be tremendous help also. So we're really looking forward to that event this year. And always when we think about the gala, we have to think about Harry Reisner, who actually developed and was chair of that for so long, but decided last year to step away. So some of what we do every year, and I'll mention just a few of those activities. But one is and this is something I think the commission and the State Bar can be very proud of, the lawyers that participate here. But we have a trial academy every year that this year was held July 8th through the 11th. Every year, the commission is partnering with the American College of Trial Lawyers and the National Institute for Trial Advocacy to conduct an intensive training for the people who are the boots on the ground, principally in this area of access to justice, our legal aid attorneys. There is a 4-day training session, and Reagan Brown of Norton Rose Fulbright secures the services of the fellows of the College of Trial Lawyers to teach the courses over that period of time. That's a remarkable investment on their part. There were 43 applications of lawyers who wanted to attend the academy this year, and 30 legal aid attorneys were able to be selected. 22 members of the American College spent time over those 4 days in that instruction. It's a remarkable investment. The State Bar has another, it was mentioned earlier, the Bar Leaders Conference, and Texas Access to Justice Commission has 4 programs that are also presented as part of that program. One is just a Access to Justice 101 session that was led this year by our staff, Executive Director April Faith Slaker, and with Betty Torres, who, of course, is the Executive Director at the Access to Justice Foundation. And we had a program on veterans, help a vet, save a life, just bringing home how severely important it is that we provide access to justice to prevent suicide, to allow our veterans to prosper as we want them to do in this state. That program was pulled together by Terry Tottenham, Robert Doggett of the Texas Rio Grande Legal Aid, and General Valenzuela, And if you missed the general's remarks at the Veterans Gala last year, you really missed a wonderful set of remarks. So he helps in many ways as a non-lawyer member of the commission, and we appreciate him. There also was a program focused on what you just considered, the use of non-attorney paraprofessionals, and the Disabilities Rights Texas Executive Director was there to help with that presentation, and they are already working on the concept of community justice workers, which we believe also will be very important as a development in addressing access to justice in our state. The final program was online tools for expanding pro bono, which was presented by Mary Rios of the Texas Legal Services Center and Brittany Crone at Houston Volunteer Lawyers. So a lot of partners in this process, and it's just always inspiring to see how many people come forward to help in so many different ways. We will continue to look for innovative ways to address the access to justice needs in our state, and with the help of the Supreme Court and all of those who participate. One very important aspect of our work this year, because of the state legislature being in session, will be our legislative work, both in Austin and in DC. And that work our committee will be chaired by Alistair Dawson, Judge Ken Wise, and Commissioner Tom Leatherberry. But all of us will be in there working on those issues, and we couldn't do that work again without our court liaison's help, Justice Busby. So one thing I would like to do is to please ask you to let us know several things, one of which is if you have special relationships with any member of Congress or any member of the state legislature, you're letting us know that and letting us use those relationships to communicate effectively would be greatly appreciated. We have seen it up close and personal, how effective walking into an office can be with somebody that was in a fraternity or sorority, or someone who was a classmate or a friend or neighbor or whatever. It just makes all the difference in the world to have that personal contact, and we really would love for you to help us identify when we have access to those kinds of relationships. And the other request is just, we, as you can tell, have a broad range of activities from time to time, and identifying people who would really like to participate but just don't know how. If you, in your firm or in your corporation or your church or your other groups, know of someone who could really both enjoy and appreciate participating with us, but help us continue to try to move the needle in these access to justice issues, we would really appreciate your helping us identify more and more, as we call them, boots on the ground. So thank you again for having us and for all you do to support the commission and access to justice in our state.
Thank you, Harriet Mier. Any questions for Harriet Mier, Chair of the Texas Access to Justice Commission? Okay. Up next will be Director Forrest Huddleston as Chair of the Audit and Finance Committee.
Thank you so much. Hi, everyone. I am thrilled to be back to give another update on our finances on behalf of the Audit and Finance Committee. Could not be more excited, so just wanted to start out by saying that. So before I jump in, I do want to say that we do have a couple of action items. So casting a vision a little bit for you guys. Pay attention today because there are 3 things that I'm going to be making a motion on, most of them related to our asset management company, PFM Asset Management, who's actually going to be speaking as well. Before I do that, I'm going to jump into just talking about the finances a little bit, and then I will go over an update on our audits that are currently ongoing. Just a reminder, so there's a difference between a calendar year end and a fiscal year end, and a fiscal year end is not always 12/31, December 31st. So we do not have a calendar year end. We have an off calendar year end ending on May 31st. I had to check to see if there were 30 or 31 days in May. May 31st. And so when we're talking about income and expenses that we're incurring, it's over the period June 1st to May 31st of a given year. So what you're looking at up here, when we say 2024, this is ending May 31st of 2024. So typically that's the way that we typically look at our income and our expenses. So just wanted to reground you guys on that. I will be going over in a couple of minutes the July ended financials. I do want to spend more time on the 12-month period ended for 2024 instead of those, because that's kind of a better indicator of our performance. We will go over in a little bit of detail the 2 months ended in July, but for now I want to focus mostly on the 12-month period here. So as you can see, we had revenues in 2024 of about 49 million. Expenses were about 44.6 million, which leaves us with net income for the year, which is obviously a good thing. The State Bar operating revenues increased by 4.1%. Operating expenditures also increased, and they increased by 5.5%. And so you guys have heard us talk about this over the last several meetings. We are seeing this trend from 2022, 23, 24, where expenditures are actually outpacing, or expenditure growth is actually outpacing revenue growth. And so we've known that for a long time. The management and the budget committee and the audit and finance committee are constantly talking about how to stay ahead of that curve and how to ensure that we have our revenues continuing to grow and our expenses not growing at the same rate that our revenues are. And so that's something that I wanted to just remind everybody here that's on the radar. There's been obviously a lot of talk about increasing dues. And so that's going to be the first kind of step to get our revenues increased a little bit, because that's a significant portion of our revenue in any given year, about 50%. And so there's conversation about that and just more conversation going on in the background about that as well. I do have something written down here that I do want to read. Another key trend that this chart demonstrates, like I said, is that the expenditures have been rising faster than revenues, as indicated by the dashed trend lines moving closer together over the past 3 years. This trend has been observed and discussed in detail during Audit and Finance Committee meeting held earlier this month. During that meeting, directors inquired about the 5% expenditure growth from last year to this year and what management has done to monitor and control the increase, because that's something that I feel like this group would be particularly interested in. Management reported that it is closely monitoring and controls expenditures of the bar using several tools, including budgeting controls, approval controls, competitive bidding, and projections. So you guys can rest assured that there are controls in place to ensure that we are going to remain with a net income in the future as well. Management also reported that the growth revenues may not remain at 4.1% in future years due to the volatility of interest rate earnings, which will be discussed here in a second from Nathan Smith from PFM Asset Management. So kind of just a quick and dirty of what our finances are looking like over the last 3 years and what we're doing in the future to kind of remain in the black. So what you'll see here is an actual expense to budget expense. This is kind of a different way of looking at our finances. What I was just looking at was actual expenses and revenues that have been incurred. This is kind of at a different angle. This is more, hey, what did we budget for and where did we actually fall out? As you guys can see, we have a positive variance right now, which is good. Our revenues were about $4 million higher than we budgeted for, and our expenses were also, let me see, expenses were about $2 million lower than we expected. So whenever you combine those two, we ended up with a positive variance this year of about $6 million, which is a good thing. I'm not going to get into the details of the revenue and expenditures. If you guys have questions, feel free to let me know, but I'm not going to get into the details of kind of what drove those changes because, like I said, I assume that you guys are more interested in kind of trends and that type of thing. So moving on to the next one. This now is moving into the July numbers, like I said. Also not going to spend a ton of time on this. This is in your guys' materials. It's 2 months of the year compared to the 12 months of the year, but overall a very strong start for the first 2 months of the year, which we're excited about. Same thing here. We have a positive variance for these 2 months. I'm going to skip forward past this. Okay. So something that I typically will report on, and I'll keep this one short because we're not done yet on this, but we have a CPA firm called Weaver that comes and does our external audit. An external audit being we put together financial statements. They look at our financial statements and make sure that the numbers are materially correct. No 100% guarantee that they're fully correct, but very standard within the industry to say, are the financial statements that you're putting together materially correct? Can an investor or can a user of the financial statements rely on these financial statements? And historically, we've had very clean opinions, which is good. I expect the same thing this year. We are going to be finishing up field work for this audit at the end of September. The audit reviews, let me see, the results of this. The Audit and Finance Committee reviews the results of this, and then we will be approving this in the next Audit and Finance Committee and ultimately bringing it to the board for approval by the board in January as well. We have another CPA firm called McConnell Jones, and they do the internal audit. And so difference between external audit and internal audit is more looking at processes and procedures to ensure that what we are reporting in our financial statements is correct. So as part of our 5-year plan, we agreed upon 3 areas that the internal audit firm is going to be looking at for this year. And those 3 are information technology, including the Security Policy Administration and Training, Security Plan, Data Protection, Incident Response Plan, Change Management, and Vendor Software SOC Report. They're also going to look at the Human Resources Department. And then lastly, typically every year, they'll look at the State Bar's investment processes in compliance with the Public Funds Investment Act. So typically we get clean opinions on that as well. I expect the same thing again this year. Okay, I'm about to pass it over to Nathan Smith from PFM Asset Management. During our fall board meeting, we typically will invite Nathan to present to us, give us an update on how our investments are doing. And this is the section that I'm going to be having a couple of recommendations on. So as thrilling as the first part of this presentation was, be sure to pay closer attention to this one. So Nathan, ready for you whenever you are.
And are there any questions for Forrest at this time before we bring on Nathan? Hearing none. Nathan, the floor is yours.
Thank you, Director Huddleston. So you have to I apologize now for the on and off of these glasses. With age, my eyes have deteriorated where I can't see here, but I can see you all, so it's kind of tricky. Copies of your most recent May 2024 quarterly investment report were included in your board books. So if you'd like, you're welcome to review those in greater detail there. Your investment policy and approach are both very conservative by design. The bar is guided by the Texas Government Code 2256 Public Funds Investment Act. And as such, in your portfolio, you'll find typical securities like U.S. Treasury securities, federal agency securities, AAA-rated money market mutual funds, FDIC-insured certificates of deposit, and from time to time, the highest-rated commercial paper, A1P1, as required by the Public Funds Investment Act and your investment policy. And you'll notice as you look through the different reports that the balances and the values of the portfolio change from period to period. And that's due in large part to when you have revenue exceeding your expenses, the value of that, changes in financial markets, and then just your liquidity needs. Your portfolio is very liability-driven, so when the bar has demands for expenses, we have securities that match the dates of those expenses and thus maturities. And so we want to keep an appropriate amount of money in liquid investments. Overall, the portfolio has a weighted average maturity of about 1.5 years, but there, like I mentioned, there's also a significant portion that's invested less than a year in the event of any unforeseen cash needs. Returns have been quite strong. As of May, your portfolio overall yield was about 5%, came in just under 5%, and that was buoyed by the Fed's high overnight interest rate as they have continued to try to fight inflation and put a lid on that. I'm happy to report that the year-over-year investment income has exceeded expectations as those short-term rates have remained elevated in spite of calls earlier this year and actually at the end of 2023 for as many as 5 or 6 rate cuts this year so far. We didn't see that. Fed funds futures had that incorrect, and many of the smartest people on Wall Street missed that as well. But as I'm sure you saw last week, the Federal Reserve cut the overnight Fed funds rate by 50 basis points, which has already begun to drive down rates, the short-term rates where your portfolio sits, overnight rates on demand deposits. And more rate cuts are expected. The next Fed meeting is November 7th, I believe. And based on Fed funds futures, for that meeting, there's about a 50% chance that they'll cut again by 50 basis points. Now, the question last week was it going to be 25 basis points or 50 basis points? There's slightly better chance of another 50 basis point cut. And then yet again, 25 basis points are priced in for the end of December. The effect on your portfolio as rates decline, because your portfolio is of such a short nature, the expectation is that the yields that are in the individual securities will be lower. And that's particularly noticeable when you have a maturity where the yields currently are 4.5% or 5%, or some of them north of 5%. When those mature in the year to come and into 2026 probably, those maturities will be reinvested at lower rates. If a 5% rolls off, it may be reinvested at a 3.5% yield. The result of that is going to be, in all likelihood, lower interest income and probably a lower budgeted amount for that going forward. One of the more complex things we do, PFM Asset Management does for the bar, is maintain a list of broker-dealers. We do have an approved list. I believe it's also in your packet. An approved broker-dealer list that we review regularly. We conduct due diligence on these counterparties. These broker-dealers are the firms that we go to, our trading desk goes to make purchases of securities, the treasuries, agencies, commercial paper securities. Part of that due diligence includes confirming that there is proper registration and compliance with the SEC and various other regulatory agencies, adequate capitalization at the firm, large market presence to make sure that they hold inventories that we can purchase from, and then company history, make sure there's no headline risk in our use of them. We also oversee the trade execution, provide information to your staff regarding the marketplace, different financial markets, and ensure the timeliness of your investment partners to deliver securities to your custodian account. And with that, I will turn it back over. Thank you for your time.
Thank you, Nathan. So this has been worked through with the Audit and Finance Committee. So these recommendations were approved for recommendation to you guys to approve. So I'll start by saying, on behalf of the Audit and Finance Committee, I move to approve State Bar Quarterly Investment Report for the quarter ended May 31st, 2024.
Coming from a committee, it doesn't require a second. Is there any discussion? Director Castle raised her hand. Do you have a question? Okay. All in favor, signify by aye. All opposed? The ayes have it.
Thank you. So on a related note, Nathan touched on this briefly, but the Public Fund Investment Act requires that the board annually review and adopt a list of qualified brokers and authorized, adopt a list of qualified brokers authorized to engage in investment transactions with the State Bar. As he said, the list of qualified brokers is in your materials, assuming you guys have already reviewed that. So I'm not going to go over it too much in detail, but it's similar to what it was last year. They will constantly assess who is on that list. And so just for your knowledge, decently consistent with the way that it was last year. So with that, on behalf of the Audit and Finance Committee, I move to adopt the current PFM dealer broker list for investments included within your board packet.
Coming from a committee, it requires no second. Is there any discussion regarding the motion? All in favor signify by aye. All opposed? The ayes have it.
Okay, thank you. Last thing here. So the Public Funds Investment Act requires that the board adopt the State Bar's investment policy as well annually, which is also in your board packet. No changes from last year, which is appropriate to the Audit and Finance Committee. Happy to entertain any questions on that. But on behalf of the Audit and Finance Committee, I move to approve the adoption of the State Bar of Texas investment policy.
Coming from a committee doesn't require a second. Is there any discussion regarding the motion? All in favor signify by aye. All opposed? The ayes have it.
Thank you.
Any questions for Audit Finance Chair Forrest Huddleston? I know that y'all are hungry. Y'all thinking, when are we going to eat? And we're going to eat. Is there any? I'm sorry. Now we'll hear from Stuart Colburn, Chair of the Minimum Continuing Legal Education Committee, who will be joining us by Zoom. And please unmute.
Greetings, everyone.
Hello.
Well, the first thing is, after that audit report, I was asked to not appear in person, but instead appear by Zoom, saving the State Bar lots of money. I also have Erica Rodriguez with me as well, who is one of the finest State Bar members that I have ever met, so or at least member of State Bar staff. We have I'm chair of the MCLE committee, and we have a report for you and some proposals. At the September 2023 MCLE committee, we came across individuals who wanted to expand the use of MCLE credit. Robert Alden, who is a member of the American Bar Trial Lawyers Association, made a presentation to us about expanding MCLE credit for attorneys that were participating in moot court or mock trial. There was a lot of support filed, letters and emails from folks such as immediate past president of the TYLA, Laura Pratt, Tim Newsom, president of the Texas chapter of the American Trial Lawyers Association, Terry Tottenham, former president, State Bar, Judge Les Hatch from the 237th District Court, David Beck also filed support, and several others. As a result of that, I convened a subcommittee, and we studied, both the State Bar and the subcommittee, studied what other states did with this type of presentation, what would it look like, what would it work. And as a result of that, we came together and passed changes to the MCLE regulations, and those changes are in your meeting materials. Real briefly, under these proposed regulations, attorneys who coach or judge moot court and mock trial competitions can claim up to 3 hours of MCLE credit for the compliance year. For those of us who've done that, you might be there all day on a Friday or Saturday. You don't get all the credit. You're limited to those 3 hours. There are provisions set forth, steps to claim that credit, and the types of competitions that we're going to allow. There are basically those from ABA accredited law schools, 2 competitions organized by an accredited university or college in Texas, 3, a state or local bar association in Texas, or 4, court of record in Texas whose judge is a licensed Texas attorney. Our committee feels this gives sufficient opportunity for all of us lawyers throughout the state to claim credit, and not just in competitions that have participants from an accredited ABA law school. Lots of discussion with the subcommittee and the committee, and that there are very legitimate competitions that some of us were not aware of, including me, all across the state that are not necessarily associated with a law school. One primary example was down in San Antonio. UTSA's Institute for Laws and Public Affairs puts on a really well-run and legitimate competition. And this is just such an example that we thought should be included in these regulations. Now, the individual attorney has to do some work here. You got to submit a certificate, which the MCLE committee will supply. And the sponsoring organization must include it in saying, hey, look, this attorney actually participated. And the MCLE regulation that we have here are only regulation changes. There are no changes to the actual MCLE rules, and therefore we only need the board of directors approval. The MCLE committee itself made the recommendation to the executive committee that met on September 5th, and that recommendation did pass unanimously. So from the business side of things, I request that there be a motion that the board of directors approve the proposed changes to section 2.1.2 of the MCLE regulations to include a maximum of 3 hours of MCLE credit for those attorneys who coach or judge mock trial or moot court competitions as set forth in 2.1.2E and F of the current MCLE regulations. And we also recommend that these changes become effective upon approval of the board of directors. And I would also like to say thank to each one of you for actually doing this, for volunteering your time on a Friday in support of our state bar. I'm always blown away by the amount of people that do so things and serve our profession. I saw past President Tisdale at the Advanced Workers' Comp Seminar, and her enthusiasm is contagious. So from me, from an attorney out here in the great state of Texas, to each of you for serving. Thank you.
Thank you, Stuart Coburn. And based upon Stuart Coburn's report, Chair of the Minimum Continuing Legal Education Committee, we will now entertain a motion to approve the MCLE Committee's recommendation to change Section 2.1.2 of the Texas MCLE regulations on accredited MCLE activities to include credit for attorney participating in moot court mock trial competitions. Director Masri, do we have a second? Second. Director Tobin? It's properly moved and second. Is there any discussion regarding the motion? All in favor signify by aye. Aye. All opposed? The ayes have it. Thank you, Stuart.
Thank you, everybody.
Thank you. Next up is a report from the chair of the DCAAP Subcommittee, Director Jeff Cochran.
Thank you. My report is pretty short. Don't have a lot to report. We just kind of wanted to update you on the status of the proposed rules that we recently put up for a vote by the State Bar membership. We did that in April. You may recall that last year the State Bar conducted a rules referendum on 12 ballot items. 11 of them pertain to the Texas Disciplinary Rules of Professional Conduct, and one of them pertained to the Texas Rules of Disciplinary Procedure. The procedure for amending the rules is specified in the State Bar Act, and it lays out a process that includes a lot of opportunities for input. The Committee on Disciplinary Rules and Referenda developed the proposals, and they submitted them to the board for consideration. As we reported in June, all 12 of the proposals on the ballot were approved by the membership. The State Bar submitted a petition to the Supreme Court shortly after the vote, and then the bar presented the results to the Supreme Court on May 6th. On August 27th, the Supreme Court issued an order approving 9 of the amendments and rejecting 3 of the amendments. The 3 that they rejected Rule 1, which pertained to terminology, but the court did adopt the proposed amendments in the existing terminology section. They just preferred that it not be a numbered rule. And then the court rejected Rule 805 and 806, dealing with the remote practice of law. The effective date for the new amendments is October 1st of this year. The State Bar disseminated information to the board and to the membership via email on August 28th. And that's about it. No other proposed rules changes have come to the DCAP committee this year. But of course, if that should happen, we would update the executive committee and this board. There aren't any plans for a referendum in the near future. And that concludes my report.
Thank you, Director Cochran, reporting on behalf of the Discipline and Client Attorney Assistance Committee. Are there any questions for Director Cochran? Is there anybody in the Zoom? Okay. At this time, we're going to take a 30-minute lunch break. Oh, my bad. We're going to recognize our Client Security Fund Subcommittee. Lawrence Morales, Director Morales. Trying to rush us to lunch.
No worries. Thank you, Mr. Chair. I have a brief report. The Client Security Fund met on September 16th via Zoom. The subcommittee reviewed 46 cases, approved 20 of them, and dispersed $133,759. For the current bar year, the subcommittee has reviewed 91 cases, approved 41 of them for a total of $254,356. There are approximately 45 cases involving former attorney Chris Pettit, who was in San Antonio. The subcommittee is going to schedule a special meeting to consider those 45 cases, to consider them because they kind of involve some unique issues. Other than that, that is the end of my report. Thank you, Mr. Chair.
Thank you, Director Morales. And again, are there any questions for Director Morales on Client Security Fund Subcommittee? Hearing none, we're going to take about a 30-minute break, not about a 30-minute break. It's not a working lunch, but we just really ask that you adhere to that 30 minutes and that we will get back in here at 12:15, starting up. Thank you. We're adjourned for lunch. Okay, thank you, and I hope you enjoyed your lunch, or you will continue to enjoy your lunch. We're going to reconvene the meeting, and we're going to hear from Cade Browning, who is the Chair of Appeals and Grant Review.
All right, y'all keep on eating. The more you're eating, the less you're listening. So I am reporting on the Appeals and Grants Subcommittee. And today we have a couple different things to consider. First, we have a grant request, and then we have 3 appeals decisions that we'll discuss, all from the Texas Board of Legal Specialization. So the first agenda item is 17A1, and this was a grant that we received. As y'all may or may not know, the Appeals and Grants Review Subcommittee receives a request for authorization when somebody seeks outside funding. And so the board policy requires internal entities such as committees and TYLA to obtain approval from this subcommittee in order to seek outside funding for their projects. And this particular grant request came from the Family Law section, who submitted a request to ask for funds from the Texas Bar Foundation to fund a project called Family Law Section Leadership Class, which it will serve as a mechanism to recruit, train, and retain Texas family law lawyers for leadership positions in the Family Law section. The class involves multiple components of leadership training, mentorship, exposure to the operations of Family Law section, pro bono work in the class project. The Appeals and Grants Committee considered this request and unanimously approved the request to seek funding from the Texas Bar Foundation, and there are no state bar funds being used for that program. Now, there's no action from y'all needed. That's a report item only. But that was the grant request. And then as we get into the appeals, this committee considers appeals from the Texas Board of Legal Specialization at issue here. And there are memos in there concerning the 3 different appeals that we heard. Now, before we get going into this, because there was also comment on it, it's important, I think, for y'all to understand kind of the parameters that we consider. And the standard is a substantial evidence standard. The substantial evidence standard is generally used from appeals from administrative agencies, right? And so the way all 3 of these appeals went with the Texas Board of Legal Specialization is for that specific specialization. The advisory committee for the Board of Legal Specialization considered the request, made their decision. It then went to the Texas Board of Legal Specialization Board, who considered that request, made their decision, and then it gives appeals up to our committee. So we are to consider that under the substantial evidence standard. So this is kind of the crux of what we're looking at. The test is whether the evidence as a whole is such that reasonable minds could have reached the conclusion that the agency must have reached in order to take the disputed action. The test is not whether the agency reached the correct conclusion, but whether some reasonable evidence exists in the record for the agency's action. So that's what we're tasked with looking at. Now, as a committee, we cannot substitute our judgment for that of the agency, and this is important in these particular cases, in my opinion. We were limited in that we may only consider the record for which the agency based its decision. The agency's findings and inferences and conclusions are presumed to be supported by substantial evidence, and the appealing party bears the burden. So our first appeal on this was from attorney David Scheller, and this was a decision that the Texas Board of Legal Specialization made to revoke his personal injury trial law specialization due to a finding of professional misconduct. The hearing was conducted via Zoom. Mr. Scheller appeared and made his arguments, as did Mr. Leo Figueroa on behalf of the Texas Board of Legal Specialization, and presented his position. Previously, the Texas Board of Legal Specialization had voted to revoke Mr. Scheller's certification in PI trial law on a finding that he had engaged in professional misconduct, as defined in Rule 8.04, the Rules of Disciplinary Professional Conduct. And the standards state, quote, that TBLS may deny certification or recertification or revoke that certification or take appropriate action upon a finding that a board-certified attorney is engaged in professional misconduct. And so based on that, During the hearing, the Appeals Grant Subcommittee heard the presentation of both parties and considering all the information, evidence, and arguments and deliberations, and in accordance with the substantial evidence standard, voted unanimously to uphold the decision of the board, of the Texas Board of Legal Specialization. Got to be careful which board we're talking about here. So on behalf of the Appeals and Grants Subcommittee, I move first that this board uphold the decision of the Texas Board of Legal Specialization revoking the certification of David Lee Scheller in personal injury trial law. Mr. Chair.
We have a motion. It's from a committee. It doesn't require a second. Is there any discussion regarding the motion? And if you have a comment, please identify yourself as a director.
Forrest Huddleston from Dallas. This may be a silly question, but bear with me. From what I remember since my time on the board, I don't remember seeing these types of issues or questions coming to us. Can you help us understand why these are? Maybe it's a procedural question, but just kind of so that we have the right lens to look through when talking about these three.
As I understand it, and I'll have to ask somebody with more institutional knowledge, but the process has been the same. There just haven't been appeals up from the Texas Board of Legal Specialization within recent memory that have gone that far. Chris, is that pretty right? So the process hasn't changed at all.
Okay, got it. That's
Does that
helpful.
make sense?
Yep, thank you.
Sir.
Any other comments or discussion regarding the motion from Cade Browning regarding revocation of the certification of David Lee Scheller in personal injury? Hearing none, all in favor signify by aye. Aye. All opposed? The ayes have it. And before we go to the other portion, are there any comments or discussion points regarding Cade Browning's report on the grant authorization request received regarding leadership class by State Bar of Texas Family Law Section? There's no action to be taken on the item. I just wanted to know if there's any discussion regarding it. Okay. Mr. Browning?
Well, I apologize for jumping the fence on that one. Okay. The next two are kind of interrelated, and some of the public comments y'all heard. They are both from sitting judges. So as y'all know, if any of y'all are board certified, there are standards that are in place for each different type of legal specialization for trial lawyers. You know, for personal injury trial law, you have to have a certain number of trials, and criminal law, a certain number of appeals, and pretty set standards. And then once you do those, you can sit for the exam. There is a exception in the Texas Board of Legal Specialization rules for judicial experience. And there's another one for, I can't remember what it's called, but it's other exceptional experiences or something like that. But the issue here is the judicial experience exception. Both of the other ones that were appealed are sitting judges that had gone on the bench, I believe, on January 23rd of January 2023. And so they had been on the bench for about a year and a half at the time of their application, más o menos. So neither of the judges met the requirements for the trial lawyers, you know, that a lawyer would meet. And so they were both proceeding and asking to sit under the judicial exception. Now, that judicial exception, it considers, it's written in there and says things such as, let's see, I've got it right here, actually. Pardon me while I pull this up. It's subsection 6C1 of the exceptions for judicial experience. And it says the Texas Board of Legal Specialization may permit a certification applicant to substitute judicial experience appropriate to each specialty area. In making this determination, the Texas Board of Legal Specialization may take into consideration the nature, complexity, and duration of the matters the certification applicant has handled in the specialty area. And both of them proceeded that we're fixing to talk about with that exception. And I'll just say the committee feels very strongly that that wording is not good. And we asked Mr. Figueroa to address it because it could lead to subjective looking at it instead of objective analysis. That's not our role here because that standard is adopted, as I understand it, and y'all can correct me if I'm wrong, by the Texas Board of Legal Specialization that then is approved by the Supreme Court. And so we have, as a committee, we felt that that language needs to be buttoned up somehow or another, either with some minimum parts or what, to prevent any appearance of any subjective looking at it. And that was a concern we expressed to Mr. Figueroa and justices. I hope that they take a look at that, and that may come to y'all to whittle on. So the first appeal was for Judge Melissa Morris from Houston. The subcommittee considered the appeal by Judge Morris concerning the decision by the Board of Legal Specialization to deny her application due to her not currently meeting the minimum specific area requirements for board certification in criminal law. Hearing was conducted via Zoom, in which Judge Morris and Mr. Figueroa both were allowed to present their position. Previously, both the Criminal Law Subcommittee and the Texas Board of Legal Specialization had voted to deny Judge Morris's application for certification in criminal law upon a finding that Judge Morris was only qualified in 2 of the 4 tasks required for certification, thus currently lacking the required qualifications. Because she didn't make the qualifications as a lawyer, she sought to substitute her judicial experience in lieu of meeting those standards, and ultimately the board and the Criminal Law Advisory Commission concluded that the judicial experience and case details provided by Judge Morris were not equivalent to the specific area requirements for criminal law, and that she didn't meet the minimum number of federal jury trials or contested federal cases and didn't have the appeals experience. During the hearing, the committee heard the presentation of both parties, and after considering all the information and arguments and deliberating, and importantly, relying on that substantial evidence standard that we talked about, voted unanimously with 1 abstention to uphold the decision of the Texas Board of Legal Specialization. So, on behalf of the Appeals and Grants Subcommittee, I'm moving that the board uphold the decision by the Texas Board of Legal Specialization to deny Judge Morris's application for certification in criminal law at this time.
Cade Browning made the motion to approve the recommendation of the Appeals Grants Review Subcommittee to uphold the decision of the Texas Board of Legal Specialization denying the application of Judge Melissa Morris for certification in criminal law, coming from a committee who does not require a second. Is there any discussion of the motion? Hearing none, all in favor signify by aye. All opposed? The ayes have it. Thank you. We have an abstention from Director Castle. We have an abstention from Director Culpepper.
Never mind. Okay, now the last appeal was very similar, but from Judge Maria Aceves from Dallas. And she had applied for civil trial law. She likewise did not meet the requirements as a trial lawyer, and her status on the bench, I believe, was the same, January 23rd, and so about a year and a half at the time of her application. The subcommittee considered that appeal, and I think it's important to say on both of these too, and y'all read in the record that we are limited to the evidence that was presented to the board, and there was no evidence of disparate treatment or somebody actually having that same experience and being admitted. If that evidence had been there, that's a real concern for the committee. But that there was no evidence presented at the board level that anybody had been treated any differently. And so we were limited in that. But that's another issue that led us to ask Mr. Figueroa to examine these judicial experience requirements and make sure they're equally applied, right? And so Judge Aceves had applied. Previously, the Texas board had voted to deny her application, the Board of Legal Specialization, I mean, for certification in civil trial law because she did not have the requisite trial experience to meet the specific area requirements. Judge Aceves' application sought to substitute her judicial experience in lieu of meeting the standards. And the Board of Legal Specialization considered the nature, complexity, and duration of the matters that she handled in that specialty area, and the Texas Board of Legal Specialization Board and the Civil Trial Law Advisory Commission determined that she did not show sufficient trial experience as lead counsel prior to assuming the bench. So we had our hearing on September 17th. The Appeals Grant Subcommittee heard the presentation of both parties and their witnesses, and after considering all the information, evidence, and arguments, and deliberating in accordance with that requisite substantial evidence standard, we voted 4-2 to uphold the decision of the Texas Board of Legal Specialization. So, thus, on behalf of the Appeals and Grants Subcommittee, I move that this board uphold that decision of the Texas Board of Legal Specialization to deny judge's application for certification trial law at this time.
Director Browning has made motion to approve the recommendation of the Appeals Grant Review Subcommittee to uphold the decision of the Texas Board of Legal Specialization denying the application of Judge Maria Aceves for certification in civil trial law. Coming from a committee requires no second. Is there discussion regarding the recommendation/motion? Director Castle.
My comments, Christina N., also known as Chrissy Castle from Dallas, Texas. My comments really apply to both of the appeals from the judges to sit for board certification. I think we as a body need to be concerned, or at least interested in, our judiciary, once they're on the bench, finding ways to become more experienced by other methods than just observing and ruling on cases in their court. I think it is a travesty that the requirements are so rigid, but yet don't clearly state standards that judges can aspire to achieve. I think Judge Bell said it best this morning in that we need to set specific standards that are clear so that we don't end up with arbitrary, or at least the appearance of arbitrary exceptions to the requirements for sitting for a board certification exam. I think there is no harm in affording our judiciary the opportunity to sit for an exam. Presumably, they are going to do all the necessary study to pass the exam. And if they don't, then they're not board certified. So while I respect the decision of the committee based on the rules as they are currently written and the standards as they are currently set, I think it is inherently an unfair process, and I think that we need to reevaluate the process, and I know there are several in the state that agree. So I just want everyone in this room to think about all the people that spoke on behalf of Judge Morris and all the people I know would have spoken on behalf of Judge Aceves had any of us thought it would make a difference given the current status of the rules. So I believe, and I ask all of you to please look at this and consider changing the rules in the future. Thank you.
Thank you, Director Castle. Any additional comments or discussion regarding the recommendation regarding Judge Maria Aceves? Director Charbonneau.
Can we put this on hold and give the Supreme Court or whoever some time to adjust these rules before we make a final decision?
Well, you have a motion on the floor to adopt or a recommendation. So in effect, the vote on the motion will dictate what you're suggesting. Yes, Director Browning.
There's also no requirement I'm aware of or rule that would not allow either one of these judges to reapply either under the current rule when they have more duration of service on the bench.
But then it would still be subjective to whoever's making, or whoever's interpreting the rules at the time that they apply. So if the same people aren't on the committee that are in the future when they apply, what's going to change? So, I mean, do they ever get the chance to do it? I mean, and what's the end game in this? I mean, because now we're fixing to make it where a sitting judge who does this specific specialization for a living can't sit for the exam that specializes her in a specific area. It didn't make any sense. I mean, I'm not saying we don't make the rules, but it doesn't make any sense because it's going to be subjective to whoever is on that committee the next time they apply. And if they end up getting turned down, it's going to be, well, we didn't think they had enough judicial experience. Well, again, I agree, Kate, the rules need to be changed on that, but do we put this on hold and then let them get the rules together and then we can come back and revisit this particular agenda item? Because it appears to me to be blatantly unfair across the board. So, because it's just subjective to whoever decides that they want to deny them. So it just doesn't make any sense to me.
Yeah, I don't know the process that the Texas Board of Legal Specialization would go through to amend their rules and submit it to the court. But as I think you're expressing the same concerns the committee had when they looked at it. But as they stand right now, this is how our appeals process works. So,
Chair, can we table this motion right now and revisit it after the committee has a chance, the Legal Specialization Board has the opportunity to resubmit some of the rules, and then this can be looked at again?
There's another comment.
Santos reminded me that the test is actually next month. Oh, it's on Monday. So if they were going to sit for the exam, it'd have to be on Monday, or they can reapply, next year.
So, but then again, it goes again that whoever's on that committee then could deny them for the exact same reasons. But we can, as the board today, say, no, we believe that they have the requisites, correct?
Well, actually, the motion is to accept the recommendation of the committee, which affirms the TBLS, the Texas Board of Legal Specialization.
So if we deny it, then they get to sit on Monday for the test?
If you deny it, then the decision of TBLS is still in place, and the test is Monday, according to some people.
So the test is, it doesn't matter how we vote then, so if we vote it down, they still don't get the opportunity to sit for the test.
I don't know I'm not sure about that. I think.
Well, then what are we voting on?
What's in front of us is, did the Texas Board of Legal Specialization and the commission, when we look at their thing, was there any reasonable reason that they may have denied their deal? We can't substitute our opinions in that, under that substantial evidence standard. And so that's the appeal that we're.
And I go back to the evidentiary part of this, to me, would be that the rule is very vague, and it was just on however somebody wanted to interpret it, not that it actually was a hard and fast rule. And again, if we deny it today, if we deny this vote and say no, they still don't get to sit for the test on Monday? And then if they don't, then what are we voting on?
And I think it is important, and I don't know if I mentioned this before, is in some of the questioning during the hearing, and committee members can correct me if I'm wrong, Mr. Figueroa did say that the duration of their experience on the bench was the reason, and with more experience, they would reapply and would have a better chance, under the standard as it sits now.
And again, experience is subjective to whoever's the person's doing it. These people are in Dallas and Harris County, two of the largest counties in this state. They have a lot of experience if they've been on the bench 20 minutes. So I guess my question is to you, Chair, if we vote this down, do they still get to sit for the test? And if they don't get to, because the Specialization Board has said that they don't get to, is it What are we voting on then? If we vote it down, we're overruling their decision, correct?
Well, no, you're not accepting the recommendation of the committee. And so the vote is on the motion to accept the recommendation of the committee regarding the denial of the applicant for the ability to sit for the exam.
I don't have my glasses.
But that is
Shannon,
based on a
what's it say?
substantial evidence or deferential standard to the TBLS. It's not a de novo standard, so we could take issue with the rule. We can take issue with the ruling perhaps, but the committee's job is to review the TBLS's decision to determine whether there was any rational basis for what they came up with, even if they may individually disagree or say that reasonable minds could differ. And so, just in a very narrow sense, the motion that's before this body is to approve the recommendation of the committee, even if we have issue with the underlying rules, which may or may not be revised in the future. Whether the applicant can sit for an exam, which is only a matter of days away, is a question that I'm not sure. I would think that would be problematic, given the short notice and the fact that the applicant may not have had an opportunity to prepare for the exam, which is on Monday or coming up this week. That may or may not address your concern and the concern of other directors, but the motion before us is simply regarding the recommendations of this committee, not the underlying aspect of the rule by which the committee is bound.
So we have no overruling authority in the specialization board. We're just saying, yeah, the committee did a good job and that's it, basically?
Well, no,
Or they did it correctly?
No, you're just voting up and down on the amendment from the committee. I'm not the amendment, the motion from the committee. And I guess characterizing it as good job or bad job or whatever, but did the committee present its report? Did they present a rational basis for its report based on its rational review of the decision of TBLS? And then we decide if we accept or don't accept the motion from the committee itself. Okay. That doesn't necessarily solve the TBLS issue for the applicant.
No, it doesn't, and
Right.
that's what
And
I'm
I know
trying to
that's your-
figure
and that's
out
your point.
here. And that's, yes, that is my whole point, and, okay.
Okay. Other discussion regarding the motion? Director Culpepper.
So, yes, Director Culpepper, I'm a section representative, and I actually just wanted to respond to some of the comments that have been made. I actually proudly sit on the Criminal Advisory Board. So we are the ones that look at these issues on a pretty regular basis. And I just wanted to respond on Jason's comments. I'm looking at you, but I'm responding to those. There you go, Paul. But to call a process blatantly unfair, with all due respect, when you're not part of that process is a little over the top. I can tell you that when we look at these decisions, we look at many, many, many applications. There is an objective standard to what the TBLS and the Supreme Court and the State Bar have decided are the standards that you should have when you're board certified. Those are objective standards. She did not meet those objective standards. I don't particularly remember her application because we see so many, but I have talked to Leo Figueroa, and she didn't meet the objective standards. When you don't meet the objective standards, then you look at subjective standards. Those are those exceptional circumstances which include judicial experience. We would have looked at all of that experience, how much experience she had, how many trials that she's tried, how many contested matters that she's seen. And we would have taken that into consideration with all of her other experience, and the decision was made at that level that she did not have the requisite experience on that subjective level. So the objective level was not met. The commission decided that the subjective level was not met. That was brought up to 2 other levels. They agreed with that assessment. So she can absolutely reapply at any time. And when she does reapply, Jason through Paul, I don't know how to do that, then she's going to have more experience, potentially, I would think, or it'll incite her or encourage her to hear more contested matters. So I just want to speak on behalf of the Texas Board of Legal Specialization, of which many of us are proud members, and say, I don't believe it's a blatantly unfair process. I do think, as Cade said, that we need to look at that judicial experience more carefully, because as Chrissy said, We want judges to take the test, but at the same time, just take those comments for what they are.
Thank you, Director Culpepper. Additional comments or discussion regarding the motion to accept the recommendation of the committee regarding the denial of certification for Maria Aceves? All in favor of the motion signify by aye. All opposed? The ayes have it. We have an abstention from Director Castle. We have an extension from Director Tobin.
Thank you.
Yes, thank you, Director Browning. At this time, we would call Director Tobin for the Professional Development Subcommittee report.
Thank you, Chair Stafford, or should I say Professor P. Staff, as I understand you're affectionately referred to here as a prestigious member of the academic community at Texas Tech School of Law.
How do you know it's affectionate? And thank you for your report. Next, we will have.
So the subcommittee met jointly with the CLA committee on September 10th in Austin to discuss new topics for CLE committee and publications. Here are a few highlights from those discussions. New TexasBarCLE.com. Texas Bar CLE is excited to announce the upcoming launch of its new website, set to go live to the public in the first week of November. The revamped site features enhanced search capabilities, improved navigation, and streamlined tools to increase the efficiency of daily operations. Texas Bar Books. Texas Bar Books recently redesigned its product pages on TexasBarPractice.com based on an analysis of customer behavior on the website. The new product pages are designed to streamline purchasing, reduce the need for customers to contact customer service, and lower cart abandonment rates. Early indications is that the redesign is working very well. Fastcase update. A number of you may realize or understand that Fastcase recently merged with VLEX. Starting on in November of 2024, all bar members will gain access to the new VLEX Fastcase, an enhanced and improved version of the Fastcase platform. This upgrade transforms how legal documents are assessed, offering complimentary access to comprehensive U.S. legal markets, and CERT, a state-of-the-art negative citator tool. Free CLE and scholarships. The State Bar is committed to providing CLE to lawyers at all stages of their practice and from all income brackets. Currently, you may receive 3.25 of your hours of CLE free in online classes. We also offer full and partial scholarships for seminars, webcasts, and online classes. Scholarships are also available for downloadable and online publications through Texas Bar Books. The process is easy, fast, and confidential. And that concludes the report.
Thank you, ATOB. Any questions? Okay. And now we'll have our report of the Insurance Member Benefits Subcommittee from Director Radha Thiagarajan.
Thank you, Chair. My name is Radha Thiagarajan. I know a lot of y'all have questions, so I just thought I'd put that out there for you. I'm here to present the general report from the Insurance and Member Benefits Subcommittee. The Insurance Member Benefits Subcommittee held its first meeting of the new bar year on September 13th, and heard updates on the bar's member benefits program. So the program consists of both insurance and non-insurance vendors that offer support and provide services to our members at discounted rates. The Texas Bar Private Insurance Exchange is a one-stop shop for members to compare and purchase products from leading health insurance providers. Members have a broad level of choices and concierge level support when they shop on the exchange. And typically every year we do a customer service or a customer satisfaction survey, and all enrollees in the exchange will have a chance to fill out the next one this spring. With respect to insurance, there will be an open enrollment for the federal individual health insurance open enrollment will take place on November 11th through December 9th, 2024. This is for plans that will begin in January. Later on in October, we'll have a webinar that will be posted online to further educate Texas lawyers about their health insurance options. And we also have the Members Health Plan, which is a group insurance plan for Texas law firms. So for years, we've tried to expand the plan to solo practitioners because currently that's not available on the individual market. So because Texas insurance regulations have not historically allowed individuals to join the group programs, we're excited to announce that in May 2023, the Texas legislature passed legislation to permit programs like the MHP to expand the definition of eligibility to include solo practitioners. The Texas Department of Insurance has drafted rules for implementation of this legislation, but has not yet finalized or published these rules. Member Benefits is anticipating an early 2025 effective date to expand the Members Health Plan eligibility to solo practicing members. So in order to educate law firms about this, the State Bar and the Exchange hosted educational presentations around the state, and these presentations took place the week of September 16th in Dallas, Houston, and San Antonio. With respect to life insurance, we actually will be increasing the rates for the first time after 5 years of significant health claim experience. The term life insurance program will implement a rate increase of 15% effective January 1st. The average increase to plan participants will be less than $12 a month based on an average benefit amount of $406,000 per participant. This is the first premium increase in the history of this program, dating back to 1973. And even with the increase, the Texas Bar Plan remains competitive in the marketplace. In addition, even as this increase goes into effect, members will have options. They can either maintain their coverage, reduce their premium, or seek alternative life insurance coverage through the exchange. With respect to non-insurance benefits, we currently have 34 benefit providers, and these range from rental cars, law practice management software, computers, professional liability, and more. The staff continues to market these programs using website ads in print, flyers, social media, and the monthly benefits email. But please do your part. If you have not visited the member benefits site recently, I encourage you to do so. It is available at texasbar.com/benefits. Moving on to our other new member benefit is BetterHelp, which Cindy Tisdale mentioned briefly. As we're excited to launch this new benefit on May 1st and are pleased so far with the results. Another new offering is Smokeball. It launched on June 18th, and Smokeball is one of our existing benefit partners, and we have offered a new benefit called Smokeball Bill. This is a standalone, cloud-based law firm billing and trust account product, which is being made available to all bar members at no cost to them or to the bar. It's designed to include everything lawyers need in order to bill their clients, get paid, and balance their books. It is basically a trust accounting compliance tool. Smokeball Bill is valued at $39 a month per user, but again, it's free to our members. As of September 23rd, 584 firms have signed up for Smokeball Bill, which represents 662 users. And that number includes about 200 signups this month alone. So this program is growing. That concludes my report. Thank you.
Thank you, Director Thiagar-Rajan. Questions for the Insurance Member Benefits Subcommittee? Okay. At this time, we're taking a public comment from Stormy Hayes via Zoom. Stormy Hayes will have 3 minutes to address the body. Please unmute your microphone.
Hello. I
can
cannot
hear you.
begin to tell you what's going on with my case and subsequent cases across the country. I had no idea the severity of it, but it's connected to the music industry and domestic violence, and these people are covering for each other. And domestic violence victims, as well as the other victims, two things needs to happen. The statute of limitations needs to be extended greatly, especially when stalking is involved, because they are trying to keep these cases out of the court and they're trying to stay out of jail. This is the most disgusting thing that could possibly be going on in this country. And I was neurologically impaired when I came upon all of this by accident. I was a victim of domestic violence and my medical records were never used. Needless to say, I could not fully understand what was happening at the time, and fraud is wrought throughout my divorce. The attorneys involved, all of them, the judge, the opposing attorney, my attorneys, they were working together. And it's got to do with covering up all of this, the kind of thing. And these people are working together through some of the country clubs, through some of the professional organizations, meeting in back rooms, so there's no electronic trail. But I can assure you, this is what's going on, and it is corrupting our entire judicial process. And for people to get fair and honest decisions, we have to have fair and honest attorneys. And this is not what we're getting. My evidence has been thwarted greatly. It's been tampered with. I had medical records from 12 years ago put back in the place where I was trying to organize my files because they were trying to gaslight me into settling for what was to keep my medical records out of the courts and to keep the prior cases out of the courts. This is unbelievable. I mean, I could not believe when I saw those records put back. I've taken them to law enforcement, but law enforcement needs to be brought up to speed on this stuff and actually do something, because the Lakeway Police Department did absolutely nothing. They did not even file a report until I brought them back in, even though 2 officers had come out to where I was. They're not doing anything about this stuff. Needless to say, the Texas Rangers need to be involved. And when local law enforcement is looking the other way, taking bribes, getting favors, we have a serious problem in getting fair legal counsel and decisions.
Thank you for your time, Stormy Hayes. Your time is up. We appreciate you being able to address this body.
Thank you.
Thank you. Now we'll hear from Director Kenda Culpepper, Chair of Affordable Legal Services Subcommittee.
Thank you, Mr. Chair. So as the chair of the Affordable Legal Services Committee, I can report that we have been working over the past year and a half on a couple of different fronts. You've heard about in our last couple of meetings, you remember that David Smith was the chair of this committee last year, did a great job. We followed the developments regarding paraprofessionals and have been considering how rules changes could expand access to justice and make legal services more affordable. Since the court's August 6th preliminary order was issued and has already been discussed in detail, a lot of detail today, we have had multiple conversations with bar staff about the proposed rules. We also had a formal committee meeting on September 12th. Chris Ritter did a great job of giving an overview of the issues. We had a robust conversation, lots of comment, some of which you've heard about today. At that meeting, we also discussed the continued interest of the Legal Services to the Poor Criminal Standing Committee in publishing prosecutor guidelines for dealing with unrepresented indigent defendants. You heard David Smith talk about this in the last 2 meetings, I believe. And as you know, this subcommittee spent time consulting with prosecutors, stakeholders, including leadership of the Texas District and County Attorneys Association and the leadership of the Legal Services to the Poor Criminal Standing Committee regarding the issue. In April of this year, after those discussions, the Affordable Legal Services Committee voted not to recommend the proposed prosecutor guidelines. And then this is kind of a new development. This summer, after the state bar rules referendum concluded, the Texas Supreme Court ordered the following language to be added. A lawyer shall not give legal advice to an unrepresented person other than advice to secure counsel if the lawyer knows or reasonably should know that the interests of such a person are or have a reasonable probability of being in conflict with the interests of the client. Obviously, this reflects directly on those prosecutor guidelines, and because of the new rule, our subcommittee continues to question as to whether any of these guidelines are necessary at this time. For all of the reasons just mentioned, there is no change in the committee's position. We obviously keep our door open for further discussion on this and other issues about how we can make legal services more affordable, and that is my report. Thank you.
Thank you, Director Culpepper. Any questions for Director Culpepper regarding Affordable Legal Services Subcommittee? Hearing none, we now call upon Director David Courageous, Chair of Legislative Policy Subcommittee, to report.
Thank you, Chairman Stafford. So prior to the 88th legislative session, during this meeting, our board would have had a notebook full of proposals from sections asking our permission to take their legislative positions forward in the upcoming legislative session. Due to the McDonald decision, sections have not requested to take a position on the type of legislation they have often sought to take positions on in the past. Accordingly, we have no request to present today. However, as you know, the Access to Justice Commission also takes legislative positions. Post-McDonald, the Texas Access to Justice Commission has agreed to submit their proposed legislative positions to the State Bar of Texas Legal Counsel for review, as they would State Bar legislative activities for McDonald compliance. No action is requested by this board today, but the proposals the commission is taking a position on will be presented to us. We do not have to approve their activity, but if we do have concerns regarding compliance, we can take steps to convey disapproval through our legal counsel. So in your materials today, you have 4 proposals that have been submitted. Number 1, the clarification that Texas Government Code 57.002 on the appointment of licensed court interpreters applies to justice and municipal courts. Number 2, creating uniformity among language access policies by amending Article 38.30A of the Code of Criminal Procedure to clarify appointed interpreters are subject to requirements of Texas Government Code Section 57.002. 3, facilitating the creation of a central legal aid intake portal for low-income Texans seeking record-clearing relief by adding TAJF-funded statewide legal aid expansion project to the list of organizations that have access to Texas criminal records under Texas Government Code, Chapter 411. And 4, increasing access to record clearing for eligible Texans and freeing up legal aid funding by automating Texas Government Code Section 411.072, clean slate automation. The State Bar's legal team and staff have reviewed these proposals, and counsel has advised that they are germane to the functioning of the courts and the functioning of the legal system and compliant with the Keller and McDonald standards. If you have any questions for me or legal counsel at this time, we will entertain them. And if not,
Hook 'em horns. Texas, Texas, yeehaw. Any? Thank you.
You blew it on the landing, Director Courageous. Any questions? Okay. No action is required or requested. Now we'll hear from Judge Jerry Bullard, Section Representative to the Board.
I don't know if I'm ever going to get used to that. Well, my voice is losing the battle with my allergies, so I was thinking about dropping my voice an octave and delivering my report using my Barry White voice. But I'll spare y'all that. Director Pratt she'd have to accompany me, so it wouldn't be it would be too time-consuming. Before I deliver the merits of the report that I have, Director Voss had given me an additional item to add to my report. And I thought, you know what? I'm going to do the addendum to my report before you hear the report. And you'll understand why here in a second. You know, for many bar members, section involvement is a gateway to bar service. We are the face of the bar. And our friend and former colleague that we eulogized this morning, Lucy Forbes, is a prime example of using section membership as a gateway to service. And the appellate section recognized that and recognized the value of Lucy Forbes' service. She was the gold standard and probably always will be the gold standard for bar service. So our section, I'm proud to be a member of, created and awarded to Lucy posthumously the Lucy Forbes Outstanding Volunteer Award. And so that is going to be an award given to someone who exemplifies exactly that gold standard that she set moving forward. So with that being said, leading into my report, you know, I got into section service involvement because of my involvement in the appellate section and in bar service because of that. And so the importance of being able to stand before you and talk about what our sections are doing on a regular basis, it's an honor for me to do that. So let's talk about what our sections have been doing. Earlier in our meeting, this board approved amendments to bylaws for the administrative and public law section, the appellate section, and the animal law section. Our new officers had an orientation in August with over 60 new section officers who had attended and taken part in that orientation. All right, now I'm going to give you some numbers, and we're going to be reminded once of all, if you weren't good at math, that's why we became lawyers, right? So I want to give you some section membership stats. There are 44,684 lawyers in Texas who are members of a section. You know, that's 39% of all of our members. Last year, 1,377 of those newly licensed attorneys joined a section directly after licensure. Over the last 10 years, there has been an 11.9% increase in the number of lawyers who have joined a section. Of the 44,684 lawyers who are section members, 22,761 belong only to one section, 12,871 belong to two sections, 5,246 belong to three sections, and 3,806 belong to four or more sections. I don't think I've gotten to four sections, but I'm pretty close. Because attorneys can belong to multiple sections at the end of the bar year, total membership in all sections is 89,545. So we have a heavy involvement in sections by all of our members. Now, as we go throughout this bar year, one thing we want to be able to do is the section representatives board, or section representatives to the board committee. I think it's the longest title of one of our committees, but any of it, what we want to be able to do is to emphasize and highlight some of the activities of our sections to let everyone know or be reminded as to how important and how visible our sections are to members of our board. So for the rest of this report, I'm going to talk briefly about section CLEs. At the 2024 State Bar of Texas annual meeting, sections were responsible for creating 78.5 hours of CLE programming, including 22 hours of ethics credit. Throughout the 2023-2024 bar year, sections were responsible for creating over 199 hours of CLE programming, including more than 54 hours of ethics credit. Ladies and gentlemen, that is a record for what our CLEs have been generated by sections. And I'm not talking about the Texas Bar CLE courses that section sponsor. This is on their own. To give you a point of reference, in 2022 to 2023, sections offered 87 hours of MCLE credit, including 16.5 hours of ethics credit. I mean, those are numbers that beat what we did during the pandemic or thereafter when we were doing a lot of things remotely. So our sections are very active in providing CLE content for their members, and for many sections, they provide them to their section members free of charge. So that's a valuable benefit for section involvement. This past year, sections worked together to cross-promote their CLEs and saw a jump in interest and attendance, which in turn fueled the sections to create even more CLE opportunities for their members. And last year, some examples of what sections had done: 21 sections hosted 1 hour of webinars on a regular basis on topics like lessons in animal law activist defense, advocating in the appellate courts, demystifying the mysteries of criminal discovery, lessons from litigating the Beatles. I would have liked to have seen that one. Discovery disputes and avoiding traps, and that's just to name a few. So your sections are doing what they're supposed to be doing. They're excelling, they're providing valuable services to their members, and we want to continue that. And so throughout this year, you all are board advisors to a section. If you see something that your sections are doing that excites you, or you think would excite somebody else, let us know, because we want to make sure that they're recognized. And our section chairs and Lindsay Jackson over the State Bar, we're going to be paying attention to what sections are doing because we want to make sure they're recognized. And that concludes my report.
Thank you, Judge Bullard. Any questions for the judge? Thank you so much. Now we'll hear from the chair of the Commission for Lawyer Discipline, Judge Monica Gonzalez, and she will provide her report.
Thank you, Chair. These are the disciplinary statistics for the quarter, June 1st, 2024 to August 31st, 2024. There were 147 complaints that were resolved through 64 sanctions. During this period, the sanctions which were imposed: 2 disbarments, 5 resignations in lieu of discipline, 17 suspensions, 5 public reprimands, 17 private reprimands, 18 grievance referral program. The amount of revenues that were collected in attorney's fees, $101,147 during this period. The Commission for Lawyer Discipline Annual Report 2023 to 2024 has been released, and it's in your materials. I just wanted to briefly thank 2 commission members that recently rolled off, Bobby Ramirez and Val Frank. They both served 6 years, 2 3-year terms, and before that, both of them had served on local district grievance committees. They really served, they were such wonderful members. Bobby is an attorney from McAllen. He was vice chair for 1 year and chair for 2 years. Val Frank is a retired critical care nurse from San Angelo. And they just both serve with honesty and integrity. So I just wanted to mention them so you know the members that are working for the bar. Thank you.
Thank you, Judge Gonzalez. Any questions? Okay, and now we'll hear from Hisham Masri and the Texas Young Lawyers Report.
Thank you, Chair Stafford. Howdy, y'all. Howdy. So it's only 1:15, but I know we're about an hour out of lunch. So hopefully this telemarketer stops bothering me so I can finish this report. But I really appreciate everyone's attention. Now, I've got a really lively report. I've only got pictures in my report. I counted it. It's about like 18 pictures, and a picture's worth about 1,000 words. So by my timing, I think we'll be like just slightly longer than the paraprofessionals discussion we had this morning. And I see Jen in the back being like, no, we will not. No, I promise to go at least a little bit more quickly than that. But like you heard from Steve Benish, and he's certainly been to a lot more places than I have, this report's really about y'all and about our committees and about our boards and the activity. And so I want to give a brief discussion and show y'all what we've been up to over the last quarter. So that picture is just down the street. It's from a games shop in Amarillo, which I think is like a suburb of Lubbock or something like that. Just kidding, just kidding. It's 2 hours north of here. But why am I showing a picture of Amarillo at a Lubbock board meeting? And y'all already heard about the sod poodles. Maybe it has something to do with that. I'm thinking I'm supposed to have a clicker. Aha, here we go, found it. All right, so these are, and I've tried to organize this sort of by month or in a timeline of ways. So in the top left, we've got our new directors orientation. That's our class of new directors on the TYLA board. We've got a great group, about 10 new directors this year that we welcomed at annual meeting this year. In the top center, we've got our TYLA Executive Committee. We went over the year, planned out our year. We met at Lost Pines, which we're headed there as a board in January. Y'all will love the resort. Y'all should try to stay there longer. There's a lot of activities for adults, and I think y'all have a lot of fun. Then we had our ABA YLD annual meeting, where both me and Armin attended on behalf of the Texas Young Lawyers Association, and I'll talk a little bit about that meeting in just a moment. On the bottom left, I, as well as our Vice President, Ashton Butcher, presented at UNT Law for, and she unfortunately didn't take a picture for us, otherwise it would be her up there rather than me. But we talked about TYLA's project Civility for All. So if y'all have connections with your local law schools and would like TYLA to visit and talk about civility in the practice, we've gotten an incredible reception to it. It's an award-winning project and certainly one that's very popular and very timely, especially right before the elections right now. In the center, we've got bar leaders. We saw many of y'all there at that meeting, and we had an incredible turnout by our local affiliates from all around the state. And it was really a great opportunity for TYLA to network, meet with its young lawyer affiliates throughout the state, and really make those connections and bonds. And in the bottom right, and I'm just now literally this second noticing that picture is cut off, that shows you how good my PowerPoint skills are. But that was at the board retreat, again, with many of y'all where we're talking about the strategic plan for the state bar. All right, in the top three, we've got Texas, did it go to the next slide? Did not, there we go. We've got Texas Tech Law, Texas A&M, and Thurgood Marshall School of Law. For Texas Tech, we have both Garrett and Laura were there representing us, as long with all state bar leadership, talking about the benefits of TYLA and the benefits of serving and working with the local bar associations. In the top right, we have our president-elect Allison Martinez, who is down at Thurgood Marshall, doing the same thing. And then me in the center with a good whoop and a good gig-em, we're at Texas A&M School of Law talking about the same things about reaching your goals. At the bottom of the panel are 3 pictures from our Amarillo board meeting. That's where the TYLA Board of Directors met about 2 weeks ago. While we were there, we had an incredible panel that included, and I'm gonna make sure I get these right, Judge Parker, Justice Parker, my apologies, see, I already got it wrong. Judge Leanne Reno, Justice Yarborough, and James Webster. And so we had a really fantastic time talking, and they were able to share with us the benefits of investing in bar service, and in particular in TYLA, as they had all been involved in the board. We're hoping to do the same type of local outreach in all of the cities that we visit and continue to really stress the importance of bar service and being active in our board. In the middle is Cadillac Ranch, an iconic spot in Amarillo where we all visited while we were there. And in the bottom right, y'all have y'all's President Bennett, with the Sod Poodles mascot. I don't remember what it is. I think it's like a gerbil or something. I don't know. I really don't know what it is, candidly. There we go. Prairie dog, thank you. You know, I did not, but like a light bulb just went off now, and now I understand the reference. Well, they were against the Rough Riders, and they lost horrifically. So go Rough Riders, which is my local team. Well, we had a good time. At each of our board meetings, as you all know, I'm a huge fan of games, and we're trying to incorporate some sort of gaming activity. Baseball is certainly a game. And so we really had a fantastic time there, and appreciate the support from the State Bar as well in attending our meeting. All right, and to our next slide. We in the top left. So Judge Bullard was very busy at this particular event, so it was difficult to get a picture with him individually. Very, very much in demand individual. So instead, I have a picture up there of all of our judges being sworn in by Governor Abbott. And the best part, or at least the third best part about the picture, is that we have East Texas A&M sign in the back. So it was really a fantastic ceremony, and really a special congratulations to Judge Bullard on your investiture. In the center, we have our Leadership SBOT class. This is where we were last week. We were down in Austin with our new leadership class. It's really a great group of people. Again, you all have already heard. It includes both Andrew Tisdale and Emily Wilkinson, and as well as 18 other students from all around the state who really come from incredible pedigree, and our future is really in good hands. I'm really excited about this year's class. The rest of these pictures are really, I'm trying to focus on, and you'll see more of them in the next quarterly reports, but the activities of our board. The two in the bottom are DAYL events that I attended. One was our Freedom one. It was a 5K, and pictured with me is our Vice President Ashton Butcher. And the bottom right is our DAYL's annual Diversity, Equity, and Inclusion event called Dinner and Dialogue. It's similar to Together We Dine that I know the State Bar has engaged in the past. And it's a program that really got me involved in bar service about 10 years ago. And then we have our director, Armin Salik, who y'all may know. He's our current treasurer, and he has two pictures up there being involved with the Dallas Women Lawyers Association and the ABA Education Pipeline Program. And we really have a very strong focus on getting our folks out there and involved. All right, so let me talk to you all a little bit about what TYLA has been up to and going to be up to moving forward. For our Law Development Committee, we're working on our Texas Law Student Hub. This is our large Texas Bar Foundation project for the year. We are rocking and rolling. This is starting to look better and better every single day. We have an idea of what the design looks like. With the help of our President-elect, Allison Martinez, who's co-chairing this committee with me. We're very much in line with having a work product that y'all will probably be able to see by our January meeting. At least that's our hope. We are working on our roadshows and grant program. So all of our, we're working on our roadshows and local affiliate outreach and trying to really get connected with our local affiliates, and if those regions that don't have local affiliates, getting out and having a TYLA local meeting so that we are more engaged and more outward-facing organization, and so that folks all around this state and all of our members kind of know about the benefits that TYLA has to provide. Our national trial competitions are well underway, and we have our coaches are helping us write a problem this year for the first time ever. We're very excited about that and that partnership and collaboration with our coaches. And we think we have high hopes for this 50th anniversary. Along those same lines, our state moot court competition, and I'll give a special shout out to Director Linehan, who is helping us write this year's criminal problem. And I've got a preview of those, which I won't spoil, but it should be at least a timely and exciting issue. I see Judge McClure in the back, who will get to timely hear the final problem by our competitors. So it should be exciting this year. And finally, I'm going to mention our podcast. This year's podcast, I mentioned before, is our Pathways to Success. We've already recorded 2 episodes. We're well underway to recording a few more about different paths that lawyers can take and how to find success in your particular path. So if you want to be a general counsel, you want to be a justice on the Texas Supreme Court, you'd like to be a managing partner of a law firm, a city attorney, how do you get there? Because last I checked, you can't go on LinkedIn and apply for most of those jobs. And so we're hoping to provide an outline for lawyers about how to get to those different positions. So I appreciate y'all's time. That concludes my report, and I'm available to answer any questions.
Any questions from TYLA President Masri or for President Masri? The animal rights section will be in touch to do a CLE on gophers, guinea pigs, and prairie dogs. That's a good TYLA idea. Yeah, no problem. Now we'll move on to liaison reports. Senior Justice Deborah Learman will now provide a report regarding the Supreme Court. Justice Learman.
Thank you so much, Chair Stafford. As always, on behalf of the court, I want to thank all of you for your unbelievable service to both the profession and to the state of Texas. All of us are truly indebted to all of you. You spend so much time volunteering to do this wonderful work. So We were all very, very grateful for every one of you. I also want to thank my colleague, Justice Busby, for being here today. You've certainly done a lot for access to justice, and we certainly appreciate your being here. I would be remiss if I did not thank the staff. I thank the staff as much as I possibly can because I owe them, as we all do, so much. We have a wonderful, wonderful staff. It's certainly Trey, Kaylin, Jen, Tracy, Chris, I mean, it goes on and on. And from the bottom of my heart and all of us on the court, we really, really do appreciate you all very, very much. Thank you. So we had our new terms just starting. We had oral arguments 2 weeks ago now, and we had our first conference last week, and we'll have oral arguments again next week. With regard to the business courts, as you all know, the governor made those appointments in mid-June, including our own Judge Bullard from Fort Worth. We're all so proud of him. We have 2 judges from each of the major metropolitan areas in Texas: Dallas, Fort Worth, Houston, San Antonio, and Austin, and more will be coming in the future. We also, of course, have our 15th Court of Appeals with the Chief Scott Brister in Scottsfield and April Ferris. We released our final rules on this court, which took effect September 1st, not a second too soon. We also released the fees for the business court. That was a little bit challenging. The court is an opt-in court, and so it makes determining those fees a bit challenging, like I said. In setting the fees, we looked at Texas data, nationwide filing fees, and ultimately landed on $2,500 for cases originally filed in the business court or removed there. On the 15th Court of Appeals, the court, with the assistance of our Court of Appeals, transferred just shy of 100 cases to that court. And these were cases that were filed between September 1st of 23, September 1st of 24, and would fall under the 15th Court of Appeals exclusive jurisdiction. So with regard to these business courts, they have concurrent, non-exclusive jurisdiction with district courts regarding, number one, a broad range of business suits, derivative proceedings, actions by organizations against its owners and managers, and actions arising out of the business organization code, and certain other business-related suits, such as an action arising out of a qualified transaction or a violation of the finance code or business and commerce code. They also have supplemental jurisdiction over claims that are part of the same case, except for medical mal, legal mal, and claims for personal injury or death. Cases can be filed directly with those courts or transferred to the courts. With regard to the 15th Court of Appeals, they have exclusive appellate jurisdiction over the following civil cases: suits by or against the state and state agencies, with numerous exceptions, including, again, suits under the Family Code, the Tort Claims Act, and claims for personal injury or wrongful death. Number two, suits in which one of the parties challenges the constitutionality or validity of a state statute or a rule, and the AG is a party. And three, any other matter as provided by law. And pursuant to that catch-all, there are some administrative appeals that used to go to the Third Court of Appeals, including appeals under the Transportation Code regarding dealers and manufacturers of vehicle license plates, and judicial review of competition rules under the Utilities Code. Also, of course, appeals from judgments of the business court. Yesterday, we ruled on our first petition from review from the 15th Court. We denied review in that case that you may have read about regarding guns and the State Fair of Texas. The disciplinary rules in August, we approved most of the disciplinary rules. It was discussed a little bit earlier this morning. 3 rules were not approved. One had to do with the request to turn the terminology section of those rules into a numbered rule. But you have to realize that the only reason we didn't accept that is because we wanted to allow for more flexibility in the future as far as changing those definitions. But we actually did accept what the definitions were and the changes as they were recommended. So in my mind, we really approved of that one, but it was just a procedural thing. We did not approve 8.05 and 8.06. These rules would have allowed the state bar to discipline Texas lawyers working in other states whose conduct violated that state's disciplinary rules, but not our state's disciplinary rules. And we felt like that simply was not fair to Texas lawyers. So I won't go through that in detail, but I encourage you to read our order. With regard to the Board of Law Examiners, in August, at the request of the deans, we amended the BLE rules to allow online, not just in-person LLM programs to count towards the law study requirement to take the bar exam. And with regard to the BOTA internal operating procedures, we did approve the BOTA requested changes to align with House Bill 5010 and the court-related changes, which allow a respondent attorney to file an appeal with BOTA to challenge a grievance classification decision. And these changes took effect immediately. With regard to the elephant in the room, access to justice, I want to first of all thank everyone for your conscientious and deliberate attention and your feedback. The court is truly appreciative of this, and I know sometimes this can be a touchy subject, something that you think that we don't want to hear what you have to say. I can promise you we do. We take what you say, we consider it, we deliberate over those things, and we truly do appreciate the comments that you've provided today and that you'll always provide us. I want to thank you all for your continued commitment to ensuring that all Texans have access to justice. As the wonderful Reverend Martin Luther King said in 1963, injustice anywhere is a threat to justice everywhere. And I know that every single person in this room is committed to that important principle. I look forward to future discussions, and I'm hopeful that together we can deal with this issue once and for all. As I have said many times, and I will continue to say, never has the third branch of government and the rule of law been more important than it is today. And as Margaret Thatcher famously said, in order to be truly free, we must have a deep love of liberty and an abiding respect for the rule of law, and that applies to every single person. Together, I know we can make this happen. Thank you all very much.
Thank you, Justice Lehrman. Are there any questions? We'll now hear from Judge Jesse McClure, who will provide a report regarding the Court of Criminal Appeals.
Good afternoon. So our term started as well in September, and we came out of the block strong and found the law unconstitutional, so that was fun. It's election related. Basically, there was a law on the books, well, I guess it's still on the books. There's a law on the books that criminalizes making anonymous communications with the intent to influence an election. And if you're going to talk about politics on the internet, that pretty much, like, why else would you do it if you weren't trying to influence an election? And so the law basically criminalized anonymous posts, and if you know your history, a lot of the founding fathers would write anonymous letters to the paper talking about how terrible the British are, and so in that spirit, we decided that that was not constitutional. I mentioned this in June, and now it's actually here. We will be in Alpine next week, hearing oral arguments. There is a delegation of lawyers and judges from Mongolia that will be there as well. There's a rodeo. These things aren't all necessarily happening at the same time, but they will be during next week. So if you find yourself with spare time to drive out to Alpine, I certainly recommend you do that. The star of the show, as far as oral argument, there's a case involving geofencing. And if you don't know what geofencing is, I'll just explain it briefly. So if a crime happens somewhere in the middle of nowhere at 3 o'clock in the morning, the police could get a warrant and ask Google, hey, whose phone was here at this area time? When we granted review of this issue, it's the first time it's come up in Texas law. When we granted a review of this issue, little did we know that in the span of about the last 45 days, the Fourth Circuit Court of Appeals and the Fifth Circuit Court of Appeals on the federal level answered this question, and they both answered the question completely differently. So I never had the grades to be a law clerk on the United States Supreme Court, but in a way I feel like I'm about to be, because I imagine the United States Supreme Court is going to look at these cases and look at this issue. But of course, we get to look at it first, so we'll see how that goes. One of the things our court does administratively, we don't have as many administrative duties as the Supreme Court, but one of the things we have is we have a grant that we use for legal education, specifically for judges and then for lawyers in the criminal justice system. And so our court right now kind of looks like a manger scene where we sit there and there's a line of people outside. They're not bearing gifts or asking for gifts from us. So we're going through a lot of that right now. Finally, next time I see you in this official capacity, our court will have 3 new members. We will be losing, I think I counted 56 years worth of judicial experience on December 31st. So pray for us, because we're really going to miss our 3 judges that are stepping off. As always, if you're in Austin, please call me. I will take you on the tour of the court. I will bribe the DPS guy to let you into the Supreme Court. You can sit in Justice Lerman's chair and spin around. We just won't tell her. So if you're in Austin, please come by. My metaphorical and literal door is always open. So if you ever have a question about anything, I'm not saying I'm going to have the answer, but if you have a question about anything, you always feel free to reach out to me. And our court loves visitors, and I know the Supreme Court does as well. So thank you very much.
Thanks, Judge McClure. Any questions? I'll be following up with you anonymously about the Mongolian rodeo. Bill Miller has an excused absence, and there is no report. Are there any questions about no report? Hearing none. Next up is the report from Judge Jeff Brown, who's our federal judicial liaison. Judge Brown.
Thank you, Mr. Chairman. To prepare for this, my first report to this board, I checked with both Chief Judge Richmond and incoming Chief Judge Elrod at the Fifth Circuit, as well as all of the chief judges and clerks of the 4 district courts. Chief Judge Richmond asked me to encourage the members of the board to engage or continue to engage in civics education in our schools and wherever else the public can be reached. And she noted that the Fifth Circuit website has resources to help with this. She also noted that at a recent meeting of all the circuit chiefs with Chief Justice Roberts, that they focused on efforts to improve the public's confidence in the courts and the bar's essential role in making that happen. On October 4th, Chief Judge Richmond's term as Chief Judge ends, and Judge Jennifer Walker Elrod will become the new Chief Judge of the Fifth Circuit. She asked me to point out for y'all a new electronic feature called the Attorney Toolbox, which allows practitioners to easily create electronic record excerpts and hyperlinks in briefs filed with the court. I have information on that for anyone who might want it. It's also been announced that the 2025 Fifth Circuit Judicial Conference will be held in Sandestin, Florida in early May. Chief Judge Godbee of the Northern District notes that his district has 2 new magistrate judges, Amy Birch right here in Lubbock and Brian McKay in Dallas. He also notes that all of the chief judges in Texas signed a letter in support of the Judges Act of 2024. It would create 66 new judgeships across the country over the next 10 years, including several right here in Texas. It passed the Senate unanimously and has 22 sponsors in the House, including 5 from Texas. David O'Toole, the clerk of the Eastern District, reports that Judge Amos Mazant was named the 2024 Baylor Lawyer of the Year by the Baylor Law School Alumni Association. And Magistrate Judge Roy Payne was honored by the Federal Magistrate Judges Association with their Founders Award. The Founders Award is the highest honor the association bestows, and Judge Payne is the only magistrate judge from Texas to ever receive it. Philip Devlin, the clerk of the Western District, notes that the district has 2 new district judges. Leon Scheidlower, I actually had to email him and ask him how to pronounce his name so I wouldn't get it wrong. It's quite a mouthful. He's in El Paso, and Ernest Gonzalez in Del Rio. The district continues to have 2 district court vacancies, both of them in the Austin division. A magistrate judge vacancy is in the process of being filled in El Paso, followed by the elevation, following the elevation of Judge Scheidlower, who was a magistrate judge in El Paso before taking the district bench. The court has also been approved for an additional magistrate judge in San Antonio, which will be filled in 2026. And finally, Sarah Medellin, the chief deputy clerk of the Southern District, mine, notes that the court has taken on 3 new judges in 2024. Judge John Kazin in Laredo was elevated for magistrate judge. Former AUSA Richard Bennett is a new magistrate judge in the Houston division, and Judge Alfredo Perez is the newest bankruptcy judge. 2 district judges, but both in Houston, have announced that they're taking senior status. Judge Lee Rosenthal, effective at the end of this year, and Judge Andy Hainan on January 5th. Those will be in addition to the vacancies created by Judge Lynn Hughes and Judge Michaela Alvarez taking senior status last year. And that's my report.
Thank you, Judge Brown. Any questions? Okay, and now a report from our out-of-state lawyer liaison, Rob Abbey.
I know you've all been waiting for this one. So for my first report, I asked our very talented staff to just pull some facts and figures to give you a sense as to how many out-of-state attorneys we have and how that's changed. And there were going to be slides, but then there were not because I did not have time. However, we currently have, as of 2023, 15,425 out-of-state and out-of-country lawyers. Most of those are not. They're here in the U.S. Interestingly, that represents a 54% increase in that number from 10 years ago. And if you want to compare that to the overall increase of Texas licensed lawyers, that was 20%. So it's more than double the rate of growth we're seeing of out-of-state lawyers. The demographics of that group roughly mirror the demographics of the in-state population. Certainly by gender and race and ethnicity, they're all about the same. About a median of 20 years of licensure for out-of-state lawyers and in-state lawyers. The median age is 49. I want to be clear, I'm on the lower end of that. And the only things that are a little perhaps unsurprising is that they're disproportionately attend out-of-state law schools, and they have a lower sort of involvement in bar activities like board certification and section membership. And really, the reason I wanted to give you these numbers was not so much because I think you're all so interested in them, but I want to ask a question to the group. What else would you like to know about this group that I can collect and bring to you next time? So please get in touch with me. I did ask where they're located, and that did spur some interesting questions. Primarily, 12% of the out-of-state lawyers are in California, followed by Louisiana, Florida, Colorado, and Virginia round out the top 5. Among that list, I looked at the states that currently have voluntary bar associations as opposed to mandatory. And so that's California recently, Colorado, New York, and Illinois. About a quarter of our out-of-state lawyers practice or live in those states. And I think if that's an issue of interest to the board, we might ask those lawyers for their feedback and what they think, experiencing both, being part of a unified bar and a voluntary bar. So that's one suggestion, but I'm certainly open to others if anybody has any. The last thing I wanted to mention was, just because it came up today, where I'm from, Colorado, we recently enacted a licensed paralegal program. It's pretty recent. We just, the rules were announced in 2023, and actually just as of this summer, the legislature approved them, and in November, we will have our first bar exam for paralegals. So we're also exploring this at the same time that Texas is. I'll plan to report back in about a year when we have some understanding of what the numbers are like. I will note that the Colorado program is a little more limited. It is limited strictly to family law issues and nothing else. And the tasks that a paralegal can do are pretty strictly defined. They are allowed to appear in court and argue on behalf of their clients. They cannot cross-examine witnesses or take evidence. One other interesting difference is, at least in Colorado, there's no income eligibility requirement. The thinking is just that the market will shake that out, but you don't have to, it's not designed specifically for lower income parties. So that's all I've got. Please be in touch with any questions. Thanks, everyone.
Any questions from our out-of-state lawyer liaison, Rob Abbey, also known as our lawyers who ain't from around here liaison? Hearing none. Ross Fisher is our general counsel, and there's no report at this time. We'll move on to Chief Legal Counsel Chris Ritter for his report.
And I'm ready now to go to closed session.
Okay, hearing that report, is there any, let's see, what time is it? 1:46. We're going into closed session based on the recommendation of our Chief Legal Counsel, Chris Ritter. It's now 1:48, and the State Bar Board of Directors will now recess the open meeting and reconvene in closed session as authorized by Texas Government Code Section 551.071 for the purpose of consulting with legal counsel regarding Boudreaux versus Louisiana State Bar Association, Turnbull versus Commission for Lawyer Discipline et al., Washington versus State Bar of Texas et al., Butler versus State Bar of Texas et al., Robbins versus State Bar of Texas et al., Turnbull versus Commission for Lawyer Discipline et al., Alford versus State Bar of Texas et al., and legal matters related to 1415 Lavaca, and as authorized by Texas Government Code Section 551.074 to deliberate regarding personnel matters. With the exception of board members, board liaisons, and section representatives, all other individuals, including non-essential staff and other guests, need to excuse themselves from the closed session. We will notify the public when we are 5 minutes out from returning to open session. It's now 1:57, and the open session of the board meeting will now reconvene. During the closed session, only matters relating to consultation with legal counsel regarding the Boudreaux versus Louisiana State Bar Association, Turnbull versus Commission for Lawyer Discipline et al., Washington versus State Bar of Texas et al., Butler versus State Bar of Texas et al., Robbins versus State Bar of Texas et al., Turnbull versus Commission for Lawyer Discipline et al., Alford versus State Bar of Texas et al., litigations and legal matters related to 1415 Lavaca were discussed. No action was taken in closed session. Now I'll ask Director Radha Thiagarajan to come lead us in the State Bar of Texas mission statement.
Thank you. I can't read that. We're almost done. The mission of the State Bar of Texas is to support the administration of the legal system, assure all citizens equal access to justice, foster high standards of ethical conduct for lawyers, enable its members to better serve their clients and the public, educate the public about the rule of law, and promote diversity in the administration of justice and the practice of law.
Thank you. We will entertain a motion to adjourn. So moved by Director Pratt, second by Director Perez.